All right, this is a motion filed, well, different motion filed. First motion was for change of custody by father. He claims that his son was sexually used while at the mother's by the child's cousin or something like this. He found out because the kids were being inappropriate at his house. And there is no showing whatsoever that I find that I think you also went in for an ex parte order from the judge, which was denied to change custody to you or to extended parenting time was filed by dad. Sir, I mean, I can listen to what you have to say, but all I can tell you is that there's nothing to indicate that the mother knew this was happening or it was going on, didn't do and has taken appropriate steps since then. I believe there's no contact with, I'm assuming that's whatever his name is, Williams. Is that the perpetrator, ma'am?
That is not a perpetrator. That's my 8-year-old nephew.
Well, who was the perpetrator?
Demetrius, the 8-year-old, another 8-year-old. That's who he's saying that did this. But when I spoke to my son and he broke down to me, he told me that it was not true, that never happened. And when I spoke to my nephew, he told me that never happened as well. My son was just in trouble. He felt like he was in trouble. So that was the first thing he said that came to his mind.
Who's investigating it?
No one is investigating it.
Was it turned in, sir, to CPS or anything?
I believe so.
Sir, did you turn it into CPS?
Yes.
Have they contacted you?
No.
And so, I mean, there has to be a change of circumstance or proper cause to even look at custody. What am I supposed to do when I don't have any child that says it's happened or nobody's investigating it? The police are not there. I'm assuming, Ms. Gates, that you're taking appropriate steps to make sure that your son is not being perped on.
Yes. When he even have his cousin over, they don't even sleep in the same area. He sleeps in my bed or he sleep on the floor on the couch, but they're never in the same bed. But my son does tell me when he has company at his dad's house, they sometimes sleep in the same bed, and I'm not okay with that.
All right, what do you got to say, Mr. Walsh?
Just at this point, just monitoring the situation, making sure that my child's safety is okay. As of now, I feel that my son is okay. We've stayed in constant conversation if anything goes wrong.
That's the best thing I'm probably going to hear today from people who are fighting all the time, is that the two of you are staying in contact and working together on this potential issue. That'll probably be the highlight of my day. Because that's what the two of you should do. Obviously, there are some thoughts of what's going on. Work together, make sure that your child's safe. That I fully agree with that. So I'm going to deny a change of custody. I don't think there's a proper cause or change of circumstance to have an evidentiary hearing. You've also asked for child support. What review? What do you want, sir? What do you want with that? For what?
I'm not sure if that was me with the child support.
All right, well then we'll deny.
Yeah, I want to be taken off of child support. I pay child support. I pay my son's medical, dental, and vision.
Is that through the friend of the court?
Yes.
What's changed?
I shouldn't have to pay child support. We split 50-50 and I pay everything. I pay my son's dental. I pay my son's medical. I pay his.
And you pay $39 a month in child support?
Yes. We both work in parents. He owns a business. There's no need for me to have to pay child support.
Sir, what's your thought on that? I mean, a child support was set in 2020. Do you think, I don't care. I'll refer it to the friend of the court and they can take a look at it of what child support should be.
The child support shouldn't be anything because
To find out from the child, well, from the friend of the court, they'll look at your income, his income, just because you have 50-50 or whatever. People often pay money, even
Yes,
when
but
they're 50-50, and he might end up paying money. You might end up paying money. I don't know.
we don't need to pay any money. We take care of our son equally. I don't ask for
There's no
anything.
agreement to deviate or anything between the two of you. And if I don't have that, I'm going to either leave it or I'm going to send it to the friend of the court.
Well, he's on
Can you,
camera now.
can you
I mean,
give us, Your Honor,
Yes.
can you give us time to sit down as adults and have a conversation?
I'm going to tell you this. I will send it. I'm going to do a referral to the friend of the court. In the meantime, if the two of you want to talk about this and figure it out or whatever, you can probably send something through. Or what do you want? 2 weeks?
I don't need another 2 weeks because I can't afford $42 coming out my check. I'm already a single parent.
That's
I buy
$42 a
groceries
month.
and stuff. I
That's
cannot.
less than $10 a week.
I
Plus-
can't do it.
I'm just telling you that it's a formula through the friend of the court that is done. If you pay or he pays, I don't know. I'm going to send it to the friend of the court for their determination. The last thing you asked for was parenting time. Ma'am, you said has a 504 plan. Doesn't get there on time all the time, whatever. Is that still a problem? School has started.
No.
All right. Then I'll deny the request for parenting time. Ma'am, let me tell you, in both of you, you got to have your kid to school on time. I don't care who has them. You got to have your kid to school on time. I can't have him missing school. Other than that,
The parenting time was for the change of the exchange date. If you look, I wanted to change it from Sunday to Sunday to Monday because we have family that stays out of town. He has an aunt that stays out of town and we have to always rush back on Sundays to be back at 6 p.m.
Your thing also said that he doesn't get into school on time, failed to take to school the entire week. You want now to go Monday to Monday, bring school records, is what I have noted. If you think that's a problem, sir, do you have a change? Do you have a problem with a change from Monday to Monday as opposed to Sunday to Sunday?
I do, because when he is in school, I would like to be prepared before the week starts. But when KJ misses, it's due to a reason. He was sick.
Well, I'm just telling you, you can't miss school without a valid reason. That's fine. End of story on that.
Yeah.
It's not him missing, it's him constantly being late to school and he's missing his time, his intervention time in the morning.
I'm telling you, you got to be there for all school activities on time. Okay?
Yes, sir.
What and you have an objection to changing to Monday?
I think it's in the best interest of the child to change it from Monday to Monday because he gets a better start on Mondays with me. The teachers even noted that he has a different behavior with me. I just want to give him a good start on Mondays and I want to have a full weekend.
But he'd have the other month.
We never get a full weekend is what I'm saying. We just would like a full weekend to where our weekends isn't being interrupted.
It's not interrupted. You go till a certain time at night. End of story.
At 6 p.m., like we have to come back in town by 6 p.m. Like if we're out of town, we have to rush back and be back by 6 p.m.
He's not out of town every week.
Well, I don't.
We do go out of town. We're not allowed to go on vacations for more than 3 days because we don't get a full weekend. We only can go on vacation for 2 days because we never get a full weekend.
Well, you'd have to be back for school Monday anyhow. You'd have to be back Sunday night anyhow.
Right, Sunday night. So if I get back at maybe 7 or 8 p.m. or at 9 p.m., that will be fine. I'm not being in violation because I have to be back at 6 p.m. But we can't take a vacation because we have to be back by 6 p.m.
And I've never stopped you when you've made a call and said, hey, I'm running late or I'm doing this or I'm still here or this, that.
Last time we went on vacation, you filed an ex parte. and said that I wouldn't bring him back. That's when we went on and that was after you gave me.
I have text messages saying that you wasn't bringing them back. That's the reason
I
why.
never said I wasn't bringing him back,
Okay.
but okay.
Well, I don't find
That's the issue, Judge. I can't take my son on vacation without having permission from him. And sometimes he gives me permission and then he takes permission back and then he goes to court and file papers on me. I just don't want to continue to have that happen when we get ready to do a vacation or go anywhere. We can't plan anything.
You can play. It's the difference between, you got an 8-year-old, so you come back at 6 o'clock as opposed to 7 o'clock.
Sometimes we don't get back in town until 8. Like we went to Kentucky and, Kentucky is a 5-hour drive. That means we have to get up early and leave in Kentucky. We can't stay and spend the day in Kentucky. Like we have to.
5-hour drive. You can leave at noon, 1 o'clock. And you still.
Right. Well, if I have family there, if we want to visit with our family up until 2 p.m. or up until 3 p.m., like it's always, we have to be back because of KJ, because he has to be back by 6 p.m. It's never that we can stay somewhere and enjoy our time with our family members because we have to be back on Sunday by 6 p.m. Monday to Monday is the same exact time. It's the same as nobody's time is getting interrupted. It's the same. It's just a full weekend. We can get a full weekend and we don't have to be back at a certain time. That's all I'm asking for.
Well, and he opposes it. And I don't see any compelling reason to change it. The two of you worked out what's going on with your son and the sexual abuse. The two of you can talk about it. If you want to submit some kind of stipulation, or if you want to ever have an agreement, you can always get a written agreement that says, okay, he doesn't have to be back at 6 o'clock and he lets him, and that kind of stuff. I'm not going to change anything at this point. There's not any compelling reason to do it. It's not like you go away every weekend. You can talk to him.
We can't right now with the judge, with the order being at 6 p.m. We can't. We just can't. So we don't.
The difference between leaving at 1 o'clock and 3 o'clock doesn't seem to make that much difference. So I'm going to deny the request. I'll send this out to the friend of the court. It may end up that he has to pay child support. I don't know.
I don't want child support. I don't want to be on child support. We don't need to pay child support. We take care of our own child. I don't feel like I should have to be paying child support. I pay my son's medical. He doesn't pay medical. He doesn't pay dental. He doesn't pay vision.
That'll be all considered in the friend of the court. We'll send it to the friend of the court. They'll contact you. Please make sure you cooperate with them. Thank you. It's gonna be a long day at this rate. Matter of Jones v. Leftridge. We have both parties present via Zoom. We have Ms. Brower from the Kent County Prosecutor's Office who filed this motion to enter a judgment of support. It says employer wages for each of them that they have, although there was no income section in there specifically. I take it both of them are employed. He at this point has 0 overnights. Calculations were made. They appear to be correct. Is there anything else you want to add, Ms. Brower?
Well, at the pre-hearing conference, I did use the parties' actual incomes. So the plaintiff earned $16.50 an hour at 40 hours per week. At the pre-hearing, the defendant indicated that he earned $17.25 an hour or either $17.75 an hour at 40 hours per week. I told him I'd use the upper number for now, the $17.75 an hour at 40 hours per week, and asked him to provide me with the pay stub, which he did. He also indicated that he keeps a minor child on his health insurance. So after he provided me with the pay stub, I did consider the health insurance he keeps on the minor child, and the pay stub that he provided comported with what he told me his income was. So as the court can see, the recommendation is a total of $446 a month in child support. I called each of the parties on July 14th, 2023, left a message asking them to call me back regarding the child support recommendation, and neither did. So that's why I scheduled this hearing for today. I am asking that the court enter the proposed judgment as well as the UCSO.
Sir, any objection?
I would like to know, can I get it like a little bit lower or something? Because this,
I don't have any valid reason to lower it. This is what the state of Michigan says you should pay. If you make this much and she makes that much, and Ms. Brower's included all the insurance and everything like that in there. I mean, everybody always wants it lower. She probably wants it higher. That's why we just, there's no room for me to move without a deviation. Ms. Jones, what about you?
I agree.
All right, then we'll enter the order as is. It starts August 1st. Good luck, everyone.
Thank you, Your Honor. Have a great weekend.
You too. Is this your last one?
Yes, it is.
All right, thank you very much.
Thank you.
Say hello to everybody on YouTube. We have visitors from Romania watching us. We have them from Traverse City. The CASA class from last night was going to be watching. In the matter of Coriano.
Yeah.
And Stressman. Mr. Stressman is here in the courtroom. You should be able to see him, I hope, at some point, but he is here in the courtroom. This, it's a motion filed by the mother regarding custody. There was a stipulated consent order for custody a year and a half ago in 2022. She now wants equal time. I don't know what reason I'm supposed to have for that, ma'am. In order for you to change custody, like you're asking for, you have to have proper cause or change of circumstance. What's the proper cause or change of circumstance other than you want equal time?
So, because of the fact that we had a few, or like when we went to our arrangements, we had a few agreements on this.
Court speaks to the court orders.
I'm sorry?
Agreements on what?
Like certain letters on the mediation that are not being followed at all.
The court order is what I follow, not mediation or anything like that. The court order, I take it. When was the mediation?
So the mediation was like December 21st, I believe.
Of when?
I would have to look on the.
You know when it was?
When the court order was filed. So the mediation that led.
Mediation led to the court order.
Yes.
So I can't go back and say anything about the court order has been in place for a long time.
Okay, I know that. And when we did go to the mediation, me and him agreed on a certain time because of the time that I was working. Also, around that time, I was definitely very fearful of Caleb Stressman. And so I made certain like agreements on it, and being like not lack of knowledge as well. I made certain agreements, and now with the agreements that we made, they're not being followed at all. So it's like, I
The
feel like
agreements that you made were in mediation, and mediation, the court order took that into consideration, and now I can't go with the mediation. I go with what is in the court order. Did you both sign the court order?
Yes, sir.
Yeah, we did, but I'm aware
Okay, well,
that
then you're stuck with
can
that
change.
agreement. What?
I said, I'm aware that can change as well.
What? The court order?
Yeah.
Yeah, you gotta have proper cause or change of circumstance. What is it?
And there is change of, I mean, proper cause right here. The fact that he's not following what was to be said, and what was in mediation, you signed it, but it goes from what's in mediation. We all signed it, but it comes from that.
The order takes into consideration all of mediation. Mediation doesn't play any part anymore. That's done. You signed a court order that was the judgment. And that means I don't look at mediation at all because it's done. You signed the court order and the court speaks through its orders. And as of right now, other than your complaint of like, you're not on the contact list for daycare, and I'm going to tell him, you better fix that and you better fix it now. No, you don't need to say anything. I'm done. Okay. You will fix that. All right. She will be on all the appropriate documents anywhere, whether it's a doctor or whatever. She is the mother, and you will not keep her out of that.
I do have a question, or excuse me, Carol, 1 second. So I'm also, another problem, it's not just the emergency list. Another problem is that, I mean, it's not even a problem. The fact that I do have my son way more than what was even agreed. So if I'm already having him this time, you know, I'm just wanting to actually have that in writing or some sort, seeing if we can change that. Because if I'm already having him that time, that would be the only difference would be the paperwork. You know what I'm saying?
What do you have to say about that?
Your
sir?
Honor, I actually have all the documentation, text messages. Started to look out for childcare because she wanted to start working more than part-time and she's going to school. So the only reason she has more time with him is because I work Monday through Friday every week. She's the first right of refusal. She has the first right of refusal to watch my son. She is his daycare as of right now. I've waited. DHS has just granted me 90 hours for 2 weeks for daycare. I have the paperwork for her to sign, emergency contact number, everything, so that I can put him in childcare because of her inconsistencies that, like, even today, I'm missing out on work today to do this every day. She just went to New York last week to pick her daughter up on Wednesday, told me Wednesday night that she would not be able to pick my son up Thursday, caused me to miss a day of work. Didn't text me until Sunday night. I didn't even hear a text back. I didn't get no text, no phone call from her. She missed her mandatory court date Monday, called me
Okay.
Monday night to cover Tuesday. She picked her son up Tuesday. Her mandatory court times from Monday at 8 a.m. until Tuesday at 6 p.m. She didn't come pick her son up until Tuesday at 8:30 with no phone calls, no text, nothing. This is as before she served me this order to come here. So in the time that she served me this paper, she still didn't have the decency to tell me that she was not going to be there. She has the inconsistency. That's the whole point of childcare. She told me to put our son in childcare.
I don't find that the two of you are supposed to work together on, just both of you stop for a minute. They're
Okay.
both supposed to work together for the best interest of your son. And if you're going to be gone and there's no reason you shouldn't ask her to watch, and if she can't, then it's your responsibility and your time. Same with her.
Yes, sir.
And I'm not going to change custody because he allows you to have some time as first right of refusal. That isn't
Part-time, her schedule changes.
Excuse me, sir. And I did get, my mother even spoke to him on
If-
Sunday and
If
asked him
there's a
personally.
violation of the parenting time, file it with the friend of the court. That goes for both of you.
Yes, Your Honor.
File
Okay.
a violation
And
with the friend of the court and deal with it from there. Otherwise, there is no proper cause or change of circumstance present to warrant a custody hearing.
Thank you, Your Honor.
And so I'm going to deny your request for any change of custody to equal parenting time. You both have joint legal custody. He will have you on all the appropriate lists. If you are not on as a, the parent or the emergency contact on any of these things, you come back and I will deal with him appropriately, and he knows how I
Okay.
feel, and he's not going to do that.
Your Honor.
And I also want to address another thing. We are supposed to come together to have to make sure that this is all okay for my son and that this is everything is being proceeded respectfully. And instead of that, I have proof of this man harassing me and talking to me so disrespectful. And all I do is
File
be
a complaint with the
respectful.
friend of the court if he's violating court orders.
Okay, no problem. Thank you. Will do.
Thank you for adjourned.
Yeah. Have a great day.
Sir, her daughter served me this paper. It's a court document. It says that this today was not supposed to.
Because you were walking away. I told you to hold on.
Just stop it. We heard everything today and it's ended, okay?
Yes, sir.
We're done.
Thank you. Thank you, sir. I
Thank
appreciate it.
We're adjourned. Thank you. You too. I think, are you on another one, ma'am?
Yeah, I am.
But against Jesus Garcia and
Yeah.
Rummel, the prosecutor, number 4.
So if I do have a problem, I just go to front of the court and deal with that.
You can go to the front of the court for any court violations with parenting time.
Okay, thank you. I appreciate that. So what was this then? What was, I thought that that's what I was doing here.
This was denied your motion for change of custody.
Okay, but if I go to front of the court and deal with that, then
I can't talk to you about the case anymore because I can't give you advice.
okay, that's fine. Thank you.
We're here. I don't know that Mr. Garcia is present. We're looking for him on Zoom, but we haven't seen him. You don't think he's here?
I don't see him in the waiting room, and this is the only person I think that I don't know who it is.
Gotta bring him in and see who is. We're just gonna check. She's got like 40 people in the waiting room that she's trying to juggle, so.
Okay.
think this is the only person.
Okay, well, this is the matter of Coriano versus Garcia. The plaintiff is here. The prosecutor, Ms. Rummelt, is here. Mr. Garcia does not appear to be here. He's in New York. I don't know. Ms. Rummelt filed a motion for entry of a judgment of support. I do see that you credited him with 45 overnights. He is mom is imputed income at $11 an hour times $35 an hour. I did go through the imputation factors and found that was probably appropriate. Ma'am, you say you're working now.
Yeah.
How much you making an hour at your work?
So I'm just a waitress, so basically it changes, it differs like every other day.
How many hours do you work?
I work up to 25 to 30 hours a week. And so we make, well, like basically I make like $3.75 like that, but then also as well as tips. So I
Where do
make
you work?
anywhere. I work at a restaurant called Taco Baracho.
Yeah. They've imputed you at an income of $11 an hour times 35 hours, and father has actual income of $21.75 an hour times 40 hours. As a result of that, there was a determination that the appropriate child support to be paid to you would be $652 per month. Ms. Rummelt, anything you want to say? It's your motion.
Thank you, Your Honor. I'm not inclined to reduce plaintiff's hourly rate. I would guess that she is making with tips around that at least 10.10 an hour at 35 hours a week, which is typically what I would impute a person. She's a little bit higher than the 10.10 at 11, but I do think that is fair and accurate based on her earning history.
Well, I think it's fair and accurate because quite honestly, you can go to McDonald's and get $15 an hour and work close to 35, 40 hours a week. Ma'am, is there anything you wish to say? Your income doesn't have as much to do with the case as does Mr. Garcia's, but Mr. Garcia is deemed to owe you $652 per month. Is there anything you wish to say on this?
No, I do not.
All right, then without objection, we'll enter the order. Ms. Rummelt, when you want to send it to me by a DocuSign?
Yes, I will. Thank you.
Well, here, thank you, Ms. Coriano.
Yeah, thank you so much. I appreciate it.
There's no proof of service, but on
Have
top
a
of
nice
that,
day. Are we all set?
yes, Ms. Zelkowski hasn't shown up, hasn't logged in. I believe she would have been given the information to log in. Her motion.
Well, she was on the phone one night.
Is she? You what?
She was on the phone with me when I walked up here. She said, "Well, you're really gonna do this to me? I'm not there." I said, "You're the one that filed the motion. I just showed up to court."
Did you miss work today?
Yes, I did.
I assume you can go back to it?
Yeah, I took off this morning. I'm leaving from here and going to meet my crew out right here in Grand Rapids to go work the rest of the day.
How much an hour do you figure you missed? You're gonna miss, what, 3 hours work?
Yeah. Yeah, so I make $21 an hour, so.
Well, she filed the motion, you showed up and she didn't. She wouldn't be under Rachel McGrath.
No, she would be under Rachel Zelkowski.
It was a custody motion filed by mom. There's no proof of service, but father is here. The case was transferred to Kent County, looks like a couple of years ago from Lake County.
Yeah, we moved from Lake County.
I'm not even sure what she's really asking for. She just says it's custody. She wants week on, week off. Is that what you currently get?
That's what it is right now, but she hasn't, so she's got a lot of health issues. She's got 2 brain aneurysms, so. Like about a month and a half ago, I dropped the kids off to her. They were there for 3 days. She contacted me and said, "I need you to pick these kids up. I can't do this. My head's all messed up." So I went and picked them up. They have not been back there since. Since then, she came out this month with you guys.
Didn't
And I
even saw an ex parte
I have
order.
1 child with her, but I have her 2. They're staying with me as well right now.
And she came to the court in, looks like August, and asked the judge to suspend your parenting rights in an ex parte motion that the judge denied.
Yeah, because what she did was, she sent her oldest to my house. Her oldest was going through some stuff. Her mom, I know she's not here to defend herself, but so what she did was she got evicted out of her place. She moved to a camper, or she moved into this guy's house. This guy is I'm not saying he's bad. I don't know that he does drugs, but it's word around town that he's,
Let me,
So all I said to her was, I don't want none of that around my kids.
I don't mean to cut you off, but it's not really even your motion.
Right.
To seeking anything, and so I'm gonna deny her motion because it's almost 9:30, you're scheduled for 8:30, you're sitting here missing work because she failed to show for her own motion. You really want it, and you say you make 21 an hour and you're gonna miss how many hours?
3 hours. I'm supposed to be working at 7 o'clock in the morning. So by the time I get to my job,
I'll give you $50 in cost if you want it, but if she's got real problems, that's up to you.
I'm not worried about it, man. I've got time to cover.
All right. Well, I appreciate that. And you're being generous, but I don't like people filing motions. And then you show up and she doesn't. I don't even know what she wants. So
I feel that. I mean, like I said, I don't know what she wants neither. Supposedly, from what my understanding was from this, is that it was supposed to be, she wanted a mediator. I said, but why did you file for a motion for custody then? You should have filed a motion in front of the court for mediation.
or even for me, I could rule on mediate, but I don't know what you want to mediate.
So
So
she wants to mediate the time, the parenting time is what I'm assuming, but like I told her, I've had them for 2 months. I'm not gonna go back and I'm not gonna force them to go.
if anything, you would have the ability to file for a change of custody if you've had for 2 months, based on the fact they've had it, but you haven't filed it, and I'm not going to do anything with it right now. Okay, so I appreciate you showing up. I appreciate you being generous to her, and it sounds like you are giving her. Because I would have ordered some kind of
I
cost.
don't want no money from her. She, like I said, she does own her own business. She does have money coming in, but she's to the point where she ain't been able to work for the last few weeks that I know of, so. I don't want to take the money out of her pocket.
All right. You're a good person. Thank you.
Thank you.
Appreciate it. Sorry you had to wait as long as you did, but
Oh, no, it's fine. It's fine. I understand. There's a whole.
there's a whole list of people, trust me. Have a good day. Take care. Both parties are present via Zoom. Mr. Walker is present with his attorney, Ms. Wolfram. This is the dad, the defendant's custody parenting time motion, and Ms. Walker Ms. English just left. And now she's back. Ms. English, can you hear me?
Hang on.
On again. And now she's back again. I was talking to her. She said stuff. No, it's not you.
I think it might be my connection.
Why don't you just not have your video on, see if it's a better connection? Can you hear me now?
Yes, I can hear you.
All right, just leave it. Maybe wherever you are right now seems to be working. Are you still there, ma'am?
Yes, I'm here.
All right. She is present via Zoom, as well as the defendant with Ms. Wolfram, the attorney. This is dad asking for a change of custody. There was a DP case ordered back in 2015 that gave mom physical custody. I don't think it even dealt with legal custody or anything. And basically, if I understand, Ms. Wolfram, mother has been vanished again from the screen.
And back.
Ma'am, are you there?
Yes, I'm here.
Oh, you just vanished again. So, and apparently, ma'am, you were bound over to court on a charge of assault intent to do great bodily harm, or assault intent to murder and felonious assault. Is that correct? Are you awaiting trial on that?
Yes, sir, I am. I pled not guilty. They want me to take a plea. However, I'm innocent, so I'm not interested in a plea. So I am going to trial because of that's it.
When is your trial set for?
Here.
I'm here.
Okay. Yeah, with that situation, I was attacked at my home
When
by
is your
a
trial
woman.
set for? When is your trial set for?
Next year sometime. I'm not sure. They're really backed up. So they said maybe next summer, next year sometime.
Which, are you out on bond?
Yes, sir.
Who is your attorney?
Ronald Lynch. Ronald Lynch.
Right. Ms. Wolfram, you've stated that the child resides primarily with the father at this point.
Currently, yes.
Mothers have some home stability issues. Ma'am, what do you have to say about this motion? I mean, I'm just going based on what the motion. What? Oh, geez.
I allow for my daughter to stay with.
Breaking up. You got to find some place where you got a connection. You just keep leaving and coming back and leaving.
Okay, I'll get somewhere where I can get a better connection. I don't know what's going
Are you
on.
driving or something?
I'm sorry?
Are you driving somewhere?
I was on my way somewhere, but when you guys called, I like pulled over and got out of the car.
I can hear
I'm
you
like
right
still in
now.
the car.
What do you have to say about his request for change of custody? Sometime
You said you can hear me better now?
I can hear you right now. We'll see how long it lasts.
Okay. Well, I'll stay put where I'm at.
All right. What is your response to their request for change of custody?
I'm not okay with that. I feel like despite of whatever situation I'm in, I've been homeless before. And I for Devenir.
Well, but you've been homeless before. You're between homes now? Hello? Ms. Wolfram,
You know, I felt like that would be a good idea for me to leave her with her dad. However, when I came home and spoke with my daughter, she told me that she just wants me to get myself together and she prefers to be with me because Devenir's mom is not so nice to my daughter. She stays with Devenir and she mistreats my child. And that's something that I'm not okay with. When he's at work, she's being talked to crazy and mistreated different ways.
You don't have a stable place to live.
I do. I currently stay with my mom, sir.
And how long have you been there?
I've been with my mom.
Oh, for God's sakes.
Shelter, and we decided to stay with my mom because I felt that was better for me and the kids. They kept getting sick while I was in the shelter. So I felt that wasn't the best place for us. So we've been at my mom's since. We have a room, we have food, they have clothes, they're comfortable. My mom helps me with daycare when she's not at work. My sister helps me with daycare when I'm not at work. I do have a stable place as well as I've been approved for stable housing. Me and Devenir, we don't communicate.
You keep going in and out, and I'm going to make this. Hold on, okay? It's clear that you've
daughter about me.
It's clear that you've had some issues regarding living in. Ms. Wolfram, has the child been staying with your client for a period of time? How long?
Yeah, for some period, probably since about April 24th. So when mom went into custody after the charge, he was able to pick her up, and she's been living
April 26th.
And so he's had her primarily since then?
Yes, and just for the court's, appraisal, he has encouraged parenting time with mom as agreed, but primarily she lives with him.
Is the child going to school from his home?
Yes.
And is registered at his location?
That's correct.
All right. It's clear that there is a proper cause or change of circumstance to allow for a custody hearing. Ma'am, I cannot change it on a Friday morning. All I can do is find that there is proper cause or change of circumstance to have an evidentiary hearing on this matter. And so I will
Okay.
have an evidentiary hearing to determine what is in the best interest of the child. We'll find out such things as an established custodial environment and things like that. You're going to be at a tremendous disadvantage if you go to an evidentiary hearing and it's you against Miss Wolfram. She knows what she's doing.
My connection is really bad and it's going in and out.
But that's kind of your fault. I mean, I keep asking and asking. I'm going to set up an evidentiary hearing. We're going to send you the information as to when. You better get an attorney. In the meantime, I will allow the child to remain with the father with parenting time to be agreed on by the parties.
Me and Devanier's never agreed on a parenting time. He's never talked to me about this. I didn't know about this situation until I got the paperwork in the mail.
I mean,
I would have never
been living there, you know, and you just keep going in and out. How am I supposed to have a hearing?
I would have never allowed for him to keep my daughter if I would have known this. She's not being treated fair and properly there, and that is a
The
concern.
ruling is of the court, okay? She's been living there since April. I'm going to allow her to remain there and go to school from there. If the parties cannot agree on some type of parenting time, which, sir, have you been allowing some parenting time?
Yes.
What kind of parenting time do you think should be right now? Every other weekend or something like that?
I mean, that's fine. I'm not really trying to be spiteful and keep her away from her. I just want to provide a better, environment for her.
Well,
I guess I would just ask the court if you feel like setting a schedule, it would probably be best to include just weekends. My client was just letting me know that he tried to let her stay overnight on a weekday and mom didn't get her to school until after 11 o'clock.
well, I'm saying every other weekend, but at this point, we'll allow every other weekend from Friday at 6 till Sunday at 6.
Sure.
And what weekend do you want it to start? Next weekend?
Yeah, that's fine.
Starting next weekend, you'll have every other weekend from Friday at 6 till Sunday at 6. This is only a temporary order, as is, and we'll set up an evidentiary hearing to determine what is appropriate for custody. It may remain with you, ma'am. I don't know. That's what the hearing is going to be about. But until then, it will be temporarily. The child will reside with the father, and you'll have parenting time every other weekend from Friday at 6 till Sunday at 6. Good luck.
Every other weekend or every weekend?
Every other weekend. Any other time you can agree on, but Friday at 6 till Sunday at 6, and we'll see what happens at the evidentiary hearing. Good luck, everyone. Thank you. Ms. Wolfram, you need to draft the order.
I'll take care of that.
Thank you.
Have a good day.
Thank you. English v. English. Both parties are present with the respective attorneys, Mr. Carpenter, Mr. Schimmel. This was a motion filed, as I understand, by the plaintiff mother for custody and parenting time. At the time of the judgment or whatnot, the parties had 50-50. And the statement is now being made by mother that Brady, who is the oldest child, has resided with mother for 2 years, and she wants to change of custody, which would sound like it's a Vadvarka matter. The daughter is a different issue, and that's one we can deal with here in a minute. But is that in essence, Mr. Carpenter, what your client is saying? Brady's living with her, has for 2 years, so it's time to change custody.
Yes, in essence, I can respond to the response in time, but my
Sounds like Mr. Schimmel, your client acknowledges that Brady does live with mom.
Yes.
Then why wouldn't we change custody?
Well, as I stated in my response, my client believes that his son may soon want to start exercising the parenting time. And
he hasn't for 2 years, and I mean, his son might also win the lottery, but I mean, there's no reason not to. I mean, I'll set up an evidentiary hearing to determine all. I can't imagine how much we're going to go through, but we'll go through whatever we have to on this, because I can't change custody here today. But the mere fact that someday he may change or do whatever doesn't, I mean, I got to deal with what's in front of me right now. There just isn't any claim that he has been residing with the father for 2 years. So it appears that clearly Vidvarka is met as far as that standard goes. There's clearly a change of circumstance since he doesn't live with his father for 2 years. I certainly would find an evidentiary hearing, because I can't change it here today. I'd like to just change it here today, but I can't. So we'll set up an evidentiary hearing on that. It's probably going to be fairly short. Is there anything regarding the daughter we need to deal with, Mr. Carpenter? I know your client says the daughter says the dad works a summer job and all this kind of stuff. Well, it's not a summer right now. Dad says he's not going to be working any more summer jobs. I see this as completely different for the daughter than for the son.
I would agree that it's completely different. I would characterize what we're asking for the daughter as a change in parenting time. When this order was put into place, the father was working as a school teacher and he had summers off. So he got a small advantage in summer parenting time, but now he's working summers. And of course, he's not working right now. He's back to his teaching job, but he'll be working a summer job again this summer. We just don't think that my client doesn't want her daughter sitting at his house alone all summer when she could be with her.
He says he's not going to be working this coming summer.
Well, he says that now.
Well, so why would I change it now? Because if you come in and have an evidentiary hearing on this, he's going to say, I'm not working this summer. And what am I going to do?
Well, because if I file this motion next spring, it'll get set for an evidentiary hearing. And then towards the end of summer, he'll go back to his teaching job and say, well, he could dodge this every summer. I mean, there are different
remedies. He's not going to dodge it every summer because he's going to make a representation through his attorney, I guess. Mr. Schimmel, is he going to be working next summer or is he going to be?
No, and he didn't even work the entire summer this year.
And if he comes
out mid-July.
And if he comes back and tries to dodge it, I've got it on the record that he says he's not going to work and there'd be no change of circumstance or anything to change this. If in fact he does and starts working come June, you'll file a motion and I'll do something even on a temporary basis until we have a hearing, meaning I will probably give her the time that he's working on a temporary basis until the start of school.
And Your Honor, I think to make it clear, she works during the week. It's not that it was the weekend. He has an extra time on her weekend during the summer, and that was what the complaint was. And he's not going to be doing the weekend work during the summer.
We'll see what comes about come next summer. Everybody's going to know what I'm going to do. Okay. I mean, if he's going to leave her sitting at home as opposed to being at mother's for day after day, I'm going to send the child to mother. All right. If he's not, then I mean, I don't know who works when and where and what, but if he changes or does something different, I'm not going to leave 14, be 15 almost by then, year-old girl sitting around at home by herself if there's another parent available for them.
We could resolve that by doing that now. I mean, if
you could resolve it by the two of you talking, but I'm not going to resolve it right here. And now you can figure that out right now. Why can't two parents with two really good attorneys figure this out right now? That it's not appropriate if somebody's going to be there to watch the child. Why leave the child sitting? Same goes for mom. I mean, if mom's working during the day, Monday through Friday, and dad's at home, and she's supposed to have the kid at some of that time, why not give him to dad? Why don't you guys start acting like adults and doing this as opposed to going to your corners and fighting? So I'm not going to change anything. I don't think shade is met as far as it relates to the daughter. The son, I will set up an evidentiary hearing. I'll also meet with the attorney sometime just beforehand. I'm not going to set up a long evidentiary hearing because it seems pretty doggone self-evident what's going on. If he hasn't seen the child for 2 years, I don't know how he could have an established custodial environment. And I don't know how I wouldn't be changing it. If the two of you can't work that out, then I'll have a hearing and you can put on what you want to put on. All right. Seems like I don't want you to, whatever you want to do is fine. I don't want you to waste my time doing something that's self-evident, but that'll be up to you guys to work it out. So as far as it relates to parenting time with the daughter, I find there's not shade and do not think it's appropriate to change the parenting time. As far as custody related to the son, I do find there's significant change of circumstance, and we'll set this for an evidentiary hearing. Okay?
Thank you, Your Honor. I'll prepare an order.
All
right, thank you.
Mother's
Good luck.
motion
Take care.
for a temporary order in this matter. So she pays for, this is regarding, I believe it's Hudson, who is 2 years old. Is that correct, Miss Garcia?
That is correct.
Right. So she pays for everything, is the sole provider and whatnot. She wants physical and joint or all the custody and stuff like that. Is there anything you want to say, Miss Garcia?
Hi, Your Honor. Thank you for meeting with me. Oh, I'm sorry.
Don't be nervous, because don't be nervous.
Okay. I have a question.
What is that?
Would it be possible to adjourn? I spoke with a lawyer at the domestic support group that I am in about 2 months ago, and she said that I wouldn't need a lawyer. However, now that Jamie has a lawyer, I feel more comfortable if I had one. I wasn't notified until Wednesday.
Oh, let me tell you this. Ms. Schindelbeck, I can probably adjourn this only because, quite frankly, it is her motion. And if she really wants to adjourn her motion, I'm kind of hard pressed not to. However, what's your thoughts on it?
Sure, Your Honor. Thank you for the opportunity to address the court, and good morning. Obviously it's her motion, so I understand Your Honor has the sort of inclination to adjourn that at her request. I will say that I have represented my client in the past related to his other children that he shares on another case that's in, I believe, Muskegon County. So I've known Mr. Sanchez for a long time. And from what I understand, as it relates to Hudson, the parties have been operating on a pretty status quo schedule for many months, where Mr. Sanchez has every other weekend and every Wednesday overnight. So obviously we'll be filing an answer, a counter complaint and whatnot. So we can come back to Your Honor when Ms. Garcia secures counsel, or she can have her counsel reach out to me and maybe we can resolve an interim order. I definitely, understand the court's position as it relates to an adjournment request of someone's motion. So we just wanted to make sure we were here today because it was noticed out, and Mr. Sanchez hired me just late last week. So we were able to get this appearance sent in and sent over, and we just wanted to be here to address the issues if that's what needed to happen.
Ms. Garcia, do you want 2 weeks?
Yes, Your Honor.
2 weeks from now, you're gonna have to be here, and if you don't have counsel, unless you withdraw your motion, but Ms. Schindelbeck is saying she's probably gonna file a counterclaim and all that kind of stuff, so she would get on here, okay? I would urge you to, I don't know what attorney told you you don't need an attorney, because you don't know what you're doing in court, and that's nothing against you, but I don't know what I'm doing when I go to set a broken arm, so we all have our expertise. So I would urge you to, are you going to be able to hire somebody within 2 weeks?
Yes.
The first thing, when you hire somebody, tell them Ms. Schindelbeck's information that you have, because there's a good chance that the two attorneys could work this stuff out. All right. Ms. Schindelbeck, I know her, and I know she can be she'll work hard for her client, but she'll work very hard to settle things and stuff too, without going into court.
Mm-hmm.
And so if you can get that, so we will, I don't know whether we should just set it for 2 weeks, to adjourn it, or we'll do a quick notice for 2 weeks adjournment.
Your Honor, could I just request, if that happens, I'm fine with that. I do have another proceeding on that day at 10 a.m. So if we could be in your first round of hearings, that would be
good luck.
Yeah, I know.
Who knows? I'll tell you, I got 40 plus motions this week. Hopefully I don't have as many. I will certainly work to try and if you can, all right, make sure you kind of. There's a motion filed by Mr. Rapier for custody of his 2 children. I think they're about 7 and 10, because he says, unfortunately, on the end of August, apparently the mother, the plaintiff died. Does anybody have a legal, guardianship or anything for these children?
No, but before they mom passed, she told me to get my kids, and that's what I'm trying to do.
Before the mom passed, what was it? You're frozen.
She told me the kids go with their father if anything happened to them. I mean, to her.
That's right. I mean, you don't really need a custody order because you're the only parent alive at this point, but I'll give you a custody order saying you get custody of the two children, even though you don't really need it because you are the parent. The grandmother does not have any legal custody at all at this point unless she gets a guardianship or something like that. But I assume that you would have notice if she's even trying to get guardianship.
Yes, sir. Yes, sir.
Can't hear you. Again, I got to talk to Mr. Ray Pierre because you're not his attorney.
Okay, she lives in Georgia though, so we don't.
Yeah, the mother.
Pierre,
Yeah. Mother.
You're breaking up.
Okay, the mother live in Georgia. Okay. No, the grandma got them. She live in Georgia, and right after the mom passed, the funeral, or like a couple days ago, the funerals, I still haven't seen my kids. It's been about 2 weeks. I haven't seen them.
Do the kids?
And I don't know why.
Is there any kind of guardianship down there in Georgia?
No.
Then I'll give you an order that you get full custody and you should be able to pick up the kids.
Right. And I've been trying to do that for
the police say you gotta
for
have
the past week.
The police say you gotta have that paper that he gonna give you. In order for them to help.
We'll give you an order of custody. We'll send it out. We'll send it out to you.
I'm down at the court office now.
I can't. You're breaking up. I mean, it's a terrible connection. I'll give you a custody order for you.
I know.
We'll mail it out to you.
Okay. I'm at.
Ask me, can you get a copy of it today?
Can I get a copy of it today?
I won't have it for you today. We'll get it.
Okay, I'm at the court office now. So.
We'll get it. We'll get it for you. We'll have it available on Monday if you want to stop by. In the afternoon.
Have available on Monday?
Yes.
Okay.
In the afternoon, if you want to stop by my courtroom.
All right.
Okay.
Good luck. Thank you.
All right.
Is that Hillary or was that
This is Frederick, come to 4F. 4F.
Okay. That's the right one.
Okay.
All right. Thank you.
Thank you.
You don't gotta worry about it. Don't spend your whole weekend worrying about this. You understand what I'm saying? Right now, what we should do.
I'd stop for you. Okay. As the plaintiff and she filed the motion, how did you serve notice on Mr. Ochoa? What?
I did it by mail.
Okay, when? You know?
The next day that I filed a motion.
So 8/18. All right. This is her motion for custody. There is an NA case, as I understand it. Is that correct? There is an abuse and neglect case filed in this matter also?
Yes.
And the children are placed with you?
Yes.
And the father has two apparent felony charges pending. Are those against the kids?
Yes.
Okay. And where are you with the NA case?
Right now we have a hearing on the 21st of October. I'm sorry, the 12th of October, we have a neglect disposition hearing.
Okay. All right. Well, it's clear that you've met the Vadvarka standards for change of circumstance or proper cause. For me to look at custody in this, I simply can't change it on a Friday morning, but I can set up a quick evidentiary hearing. I understand that Mr. Ochoa is on the run, possibly.
Yes.
Well, we'll do our best to serve him. Just so you understand, no matter what I give with custody, I can't override the NA case, but you've got custody of the kids anyhow right now. So
yes.
I'm just telling you, we will have the hearing. Who's your attorney through the NA case? Did they make a big impression on you? Male or female?
It's a female. I'm sorry, I'm a little nervous and I totally forgot her name, but I.
Oh, don't be nervous.
already
What
spoken
do you
with
got to be nervous about? You're talking to a screen and me. Okay, there's nothing to be nervous about. For all you know, I'm sitting here wearing shorts.
I know, but this is my kid, and we've been through so much.
Oh, goodness.
We're looking.
You didn't make a big impression on you.
It is,
Let me.
Audra McClure.
Her name is Audra McCloy. McClure.
Okay. Talk to Audra as your attorney. Tell her that you've got this custody case. We're going to have an evidentiary hearing on it. Because
Okay.
they probably would like to have you get full custody, and then they might dismiss the NA case. Okay. Talk to
That
Audra.
is what she said, yes.
And if she needs to contact me, we might be able to see if we can get you some help in the evidentiary hearing, if possible. So talk to her, tell her that we're going to set up an evidentiary hearing for a custody. She can call my office if she needs to talk about what we can do or something with it. Okay. So
Okay.
all I can do is I will set up and at this point, and I will also give you a temporary order at this point that gives you full legal and physical custody with I assume he must have a bond that doesn't even allow him to have is that correct?
I know he has a warrant status, but I don't believe he's arrested.
All right, let me just see what do you have an order through the NA case that does not allow him to have contact with the kids?
Yes.
All right, so I don't need to put that in. We'll see you here as soon as we can get you. Do contact Miss McClure and tell her to contact my office, okay? So we can see if we can get you through this as easy as possible. All right, we'll send you notice of when an evidentiary hearing is set for, and we'll see you then, okay?
Okay, thank you.
Thank you very much. Take care. Never been on.
Yes.
You pulling your hair out yet?
Can you tell? Tracy's completely bald.
I can only imagine. I was like going, oh man, I'm sure that it's say you have to be burned out.
Thank you for realizing that. What is it? You're not sending notice to these people so that you win?
Actually, it's his motion. I'm defending it. So I don't need to notice.
All right, sorry, I can't yell at you for something like that, even if I make it up. This is Black versus Miss Black is here with her attorney, Mr. Krupp. This was Dad's custody motion, stating, I don't know, mom calls her the child names and has slapped her and is taking her phone away and doesn't want to be at mom's and all whatnot. However, it does not appear that, let me just ask you, Mr. Krupp. CPS was contacted, I think, but has there ever been any CPS substantiation?
No, and he was the one that called CPS. So he called CPS so he could put in the motion that CPS was called. Well, he called them. So
yeah, I mean, CPS can be called without a substantiation doesn't mean much of anything. I mean, I can call CPS and you. And,
well, exactly.
And they'll come and investigate. Although they may find something with you, I don't know. All right, since he's not even here to pursue it, and it is his motion, I'm assuming the child's still with mom and attending school and stuff like that?
he actually has gone rogue. He took the child and then won't return her.
All right, we'll issue an order that he is to immediately return the child to mother. I guess we can try and put in, I'll see if I can put in the language that she can use the police to do it.
Okay. Do you want me to do the order then?
That would be even better. Because
Okay.
I'm still going and if you can send the order through, that would be helpful.
I'll do it right now. You want me to just email it over?
Yeah, because he's to immediately return the child to the mother. And quite frankly, because he isn't here, even though it's his motion, I would entertain some attorney's fees on it.
Right. Well, in my answer, I'd requested 1,500 in attorney's fees, but obviously whatever the court's discretion. It's been at least 2 hours and then I have preparation time. So at $400 an hour.
Well, I'll state for the record that I do know Mr. Krupp's practice. I don't, do you know where that fits in within the, the state bar?
It's within it's $400 per hour. For 3 hours would be $1,200. And after preparing the motion and sitting here today, I spent at least 3 hours.
I usually never give the full amount of stuff like that. I'll give you $1,200. I believe that your representation, I do know the extensive amount of work that you have in this area is clearly extremely high. And that the amount appears to be appropriate. 3 hours, considering that you've had to wait and that you also have had to prepare an answer, as well as I'm sure discuss this with your client. And wait here is not unusual. I think he should be required to pay $1,200 in attorney's fees also, especially considering that you're going to be required to prepare the order. If you can get it over here sooner rather than later, because I'm not going to be here. I might be face down on my desk in an hour. So,
I will literally, as soon as I get off the Zoom, I'll hurry up and get it over to you.
All right. Good luck.
Okay. Thank you. Take care.
You too. Have a good evening. Present by Zoom with the respect we attorneys.
It feels like an evening,
Ms.
doesn't it?
Judd for the defendant and Mr. Dooley for the plaintiff. This was the plaintiff's motion to set aside an ex parte and seek parenting time. Claims he hasn't had parenting time because mom is alienating the kids. I'm going to cut to the chase here. Mr. Dooley, you did agree to leave the ex parte order, you and your client, in place on 4/7/23. Why is it now that everybody's the bad guy? You agreed to it.
I agreed to it. That's correct, Mr. Fredericks, because we thought we had cooperation from the other side. We thought we had cooperation from Tracy. And we thought with the help of Kurt Visker, we could reunite these boys with their father.
Do we have anything from the counselor that says, that it's just not working or anything? Does anybody have anything?
I have been in touch, Referee Frederick, with Kurt Visker on many occasions. And he basically says the boys will not cooperate at all. They will not do anything. And he has no initiative or cooperation from Tracy. I asked him to provide that in an email to me this week. I have not gotten that.
Do you have anything, Ms. Judd, from him?
I have had the exact opposite experience, Your Honor, with Mr. Visker, and he's actually authored letters to the contrary that the court has in the file. And I'm a little shocked here that I haven't heard from the other side since he failed to appear for the case conference in June. Not a single phone call, nothing. I haven't done anything because I haven't heard of a single problem here, but we have an order that says the ex parte remains in place until an evidentiary hearing. If we want to have an evidentiary hearing, if Mr. Zazelski wants to do that now, I guess we can do that, but I'm really discouraged by this new bucket of darts that we're trying to throw at the board about alienation.
There is the order that suspends his parenting time as of December 1 of 2022, and it was agreed that order would remain in place as of April 7, 2023. If you're asking for an evidentiary hearing regarding it, I'll give you an evidentiary hearing. We had case conferences to see where things were going in the hopes. I thought that we'd be making some progress. It also stated in an order that he could set up time. Where is that? As I recall, that he could set up time through like journeys or something if he chose to do so. And I didn't see any that he's tried to do that.
No, because what happened was, is that the parties agreed that the journeys things was not working. So they went with Kurt Visker. The last, you have the authority to give some type of temporary parenting time. And I have three, pardon me?
I do have that, but.
Well, can I finish?
No, can I finish? I'm telling you, I do have it, but I'm not inclined to do that. We've been trying to work with it. I'll set up an evidentiary hearing.
But in the meantime, excuse me?
I'm glad to set up an evidentiary hearing.
The last communication I had from Visker was that he wanted these boys to spend time with Rick. And he even offered that in emails to Tracy. They were not responded to. And
Why don't I have that?
Why don't I have that?
Why don't I have that?
I suppose we can get that to you right away.
I mean,
I do have that. Actually, council does have that because Tracy was sent those. She has those emails from Bisker.
I meant from you, Joe. If there's a problem, why don't you call me or email me? I haven't heard from you in 3 months.
The reason is every time we go to court with this type of case, you take the position that your client takes, and that is there is something wrong with the parenting time when in fact your client spoke to the police department and said there was nothing to be afraid of. Your client does not participate. Your client cancels appointments. It goes on and on and on. It is
Well,
not.
what happened to the case conferences that I tried to set up and people didn't?
We were there.
I was here.
My client was participating with Kurt Visker. He was doing
No, the case
everything
conference with me.
I understand that. And we told you that he was participating. The boys won't participate with counselors. That's where we are.
We'll see where that comes out in an evidentiary hearing.
When can we have that?
Miss Dewey will be checking with you sometime probably later today to figure it out. Or tomorrow, Monday. We're still in motions. I started at 8:30.
I understand that. I understand
We
that.
will get to it when we can and we'll figure out when an evidentiary hearing can be had. Until then, you're gonna live with the order that you signed, that you stipulated to, that still suspends parenting time. We better get some, if you're gonna even have any chance of getting parenting time before that, I'm gonna need some from Mr. Visker. I don't have anything, just everybody saying, Miss Judd saying one thing and you saying the other. I don't know what it is. Somebody provide me something.
I'll provide that to you. I'll provide the emails and I'll provide Mr. Visker's email.
First,
I'll get 'em.
you will provide it to Miss Judd before
Of
you
course
provide
I
it
will.
to me.
I would,
Anything you provide to me has to go to Miss Judd also.
I would hope after our professional relationship, I do that.
I'm just putting it on the record. I assumed you would, okay?
Okay, all right.
You also need to contact Diane Hill, Mr. Dooley.
Oh, yes. I realize that.
You have to contact her by Monday.
Thank you.
Thank you. Anything else, Miss Judd?
Nothing further from me, Your Honor.
All right, we'll get you time. We'll contact both of you. Thank you.
Thank you. Have a nice weekend.
I assume we're adjourned. This was father's motion regarding custody and for payment on house proceeds. There was a judgment of divorce just entered the 1st of April, pretty much. And since that time, father says there's been a change of circumstance. Mom moved 90 miles away and she's still within her rights, but I think, sir, you're saying that she's changed schools, and with joint legal custody, ma'am, you can't change schools without a hearing unless he agrees to it. There's also a motion for payment of house proceeds. I'm not sure that I know exactly how much should be paid, but it clearly looks like you were supposed to split proceeds and it hasn't been done yet. Does that pretty much state what you're seeking, Mr. Bauma?
Yes, Your Honor.
Ma'am, what's your response?
False.
False what?
Well, that's what he's trying to come after me for, but, and as far as schooling went, I went down there to file a motion for that, and the lady there, the clerk lady, even had her ask her supervisor, because my lawyer did tell me for that, I would have to possibly go to court for school choice, for change school districts, and so I went down there to do that, and also to, file a, what's it called, for him too, for other things, and she told me I didn't have to. That's why I told her my lawyer told me that I might have to though. I said, could you make sure with your supervisor? So she walked back.
I don't even know who you're talking about because clerks can't give you that kind of advice. All I can tell you is by law, you cannot change a kid's school district when the both of you have joint legal custody. If he disagrees and you want to change, you can't change until I allow you to change, which means the girl has to continue to attend where she was.
She wasn't the clerk. She was a lady that when you file for these orders, to go to court for, it was them. And then the one that you go downtown into the court,
I have no idea who's telling you that. All I know the law. I don't know who's telling you.
I'm not saying you're right. I was just saying I tried doing it. I thought I had to too, but then when I went down there to do it, I was told I didn't have to.
Well, that's wrong. You cannot change school districts unless Mr. Bauma agrees. I mean, the two of you can always agree on stuff, but if he doesn't agree, and he doesn't, then the child will continue to attend, what is it, Thornapple Kellogg? Is that where?
That's where she
Yeah.
was, but we are not in district. Neither one of us. That was the arrangements as if we were both living there in our court papers, but neither of us are living in Middleville now. So we don't qualify even for her to attend. I wouldn't be able to get her there as I am here now. And I asked him though, in the beginning, I have text to prove it and everything. I tried conversating, talking about switching schools because neither of
Doesn't
us
matter. If
were.
you guys can't agree, then I have to do it. It doesn't matter whether he agrees or, you say I'm trying to work with him. It doesn't matter. Okay. The bottom line is, how can she not attend Thornapple Kellogg if that's where she was attending?
I'm not in the area. I don't live there. I'm the one taking him to school and back.
Sir, can she even attend Thornapple Kellogg?
She can, and I had her enrolled there in early July through School of Choice because I live in Caledonia, which is about 15 minutes from Middleville. And I had all that stuff set up with TK Middle Schools. I have emails with the staff there stating that she was good to go. And that was July 10th when I emailed and inquired about making sure that she would still be able to attend there. For the main reason because she's a junior, I just wanted, this is a crucial point in her life.
Yeah.
But
if she can attend there and she was attending there, you can't take her out of there unless I tell you can. And I got to have a hearing to say that.
Okay, I went there to do that, and that's when I was told that, so I didn't know what I was just doing. I understand what you're saying.
I'm not even holding you. I'm not saying you didn't. Okay, all I'm telling you is the law that she has to attend Thornapple Kellogg until I tell you you can move, unless Mr. Bauma, you can move any place you want. You just can't move the child.
Yeah. So that's the other thing with that. Mr. Bauma wasn't present for the kid's life and active in the kid's life either during this time of decision. He was not doing his.
This is what the law says. You have joint legal custody. Okay.
Mm-hmm.
All decisions that are made that have substantial effects on the kids have to be agreed to. If not, then I have to have a Lombardo hearing, is what it's called, to determine what is appropriate. I could decide that the child should attend. I don't know where you live, but I can't do it here because I got to have evidence to see where it's appropriate, including best interest and all this kind of stuff. Until then, she has to attend Thornapple Kellogg until I allow it to move. And I can't do it on a Friday morning. I have to have an evidentiary hearing. In the evidentiary hearing, you guys should have figured this out before that you were fighting, because it's not going to happen for 2 months. And until then, she's responsible to be attending there. You can move anywhere you want, but the child stays at the school.
Okay, so that's the problem too, is she's in the school now because of what I was told there when I went down to file.
I don't care what you were told.
I understand that, but she's already pulled out now, so now it would be technically school choice. I would file an application for my.
That's like saying that I violated the law and now I'll just have to go along with it until some other time. If Mr. Bauma is saying to me that she can go to school there come Monday, she has to go to school there come Monday. If they won't allow her there, then that's something different. But he is saying that she is to go to school there.
He can't get her there.
What do you mean he can't get her there?
He won't be able to get her there. That was part of our issue back then too, was why the custody was the same. He can't get her. It's school choice. He's not in district. Buses don't attend there. So he would have to be responsible for picking her up.
What you're saying to me is you can move anywhere you want and take the child and just, that I win because I take the child.
No.
And now he can't get her to school. So I just take her and force him into that.
No, he wasn't able to do it before, even in the past. He wasn't active to be able to do anything. He didn't have a license for
You
a
guys
while.
just ended up divorced 4 months ago. All right.
Yeah.
Until then, I don't know what your situation was, but you were married. All right. So all I'm saying, sir, take your hat off. All I'm saying is that I can't change a school without having a hearing unless you guys agree. So she has to go to Thornapple Kellogg. You're telling me what?
She's not in there no more.
That's because you did it illegally.
Yeah, but I didn't know that because I tried. I
So
thought
what? I'm telling you, send her back. Thank you. And then we'll have a hearing.
it's good. Okay, so now I have to send an application for school choice, and it's going to take a while. And I have to have transcripts. Again, I'm sorry. I thought I was doing right. I went down there to file this, thinking that I had.
How do you expect to fix this now?
Me?
I just asked Mr. Bauma.
Oh, sorry.
Well, I was hoping that Mackenzie could just live with me during the school year so she can finish her last 2 years at Thornapple Kellogg. And I have a way to get her to school. I have close friends of mine that live in the Middleville School District that they've agreed that I could drop her off to their house on my way to work in the morning at 5:30
and she can take the bus from their house because.
I'm just asking you, do you think that is really the best interest of your child?
Absolutely. For her mental and emotional and.
Where's she going now?
Edwardsburg.
And it's been for like 1 week?
Yes. And it's good what she wants to go for a career. It's got for sports wise, what she's going to school for. It's everything. It's got district.
You did get the approval for her to play softball this year? Because I was last understood she was going to have to sit out a year.
And if she goes to school of choice for Middleville, she will too.
No, she won't. She was already at Middleville last year. She
District. Yeah, but she was there she lived there.
never left school though.
She did.
I already had confirmation from the athletic director.
But I also have when you do have them, you're not taking care of them. And I'm
not changing parenting time or anything. I'm just saying she has to go there until the time comes. If you guys have to work something out to get her there, then you have to work something out to get her there. I can't just change it here today. And I think, you keep saying somebody down there told you. I don't know who even told you, who told you that. I have no clue.
I mean, I got paperwork filed to send him papers. If she's on that paperwork, I mean, that's who told me. Like, I am frustrated because I tried doing it right. And here I am because they told me I didn't have to.
Why didn't you hire your attorney?
Because she told me she didn't think I need a lawyer for this. My lawyer, because this first time he tried doing this, he tried being sneaky and didn't send me papers for you. And so the lady contacted my lawyer to tell me I had court the next day. And she was like, she sent me it. She's like,
who's your lawyer?
Michelle Giorgio. She was only for my divorce though. So he told all the courts that she was still my lawyer. So the day before court, she got a notification that we have court, and she sent it to me saying, did you need me for this? She's like, did you know about this? I'm like, I had no idea. So she was like, you want me to reply back to that lady at your, the one that your assistant or whatever, to tell her that unaware? I said, yeah.
Who's telling you this?
My lawyer.
Okay.
But she wasn't hired for this. So he thought she was. He thought he didn't send us paperwork that he was told and was supposed to do. So they canceled, the lady at your office canceled his first attempt as like, this is a game to him. Second attempt, again, this was supposed to be 2 weeks ago. She said he played along saying that I had court still, when I'm like, Mike, you knew I was going away when you planned this. So I called.
When did somebody down here tell you that you could change without going to court?
The lady that I went to file a motion for at the court system. The people up there have to file with.
When?
Let me see. Hold on, I can look right now.
Is it a week ago or 2
No.
months ago?
I think about a month and a half ago. I have the date on these papers that I was filing. Hold on.
If it was a month and a half ago, then why did you just get the transcripts on August 29th, take her out of TK and transfer her to Edwardsburg? That was a week ago.
Yeah, Michael, I was getting the okay before I made any final decisions on moving down here.
You moved down there.
Yep, there you go. It was right before I moved down here.
Should have done that before. And Your Honor, with the first motion that I filed back in the end of May or the beginning of June, I made the mistake of sending her copy to her lawyer and not to her. So it became null and void. That was the issue with that. I wasn't trying to be sneaky. I just sent it to her lawyer thinking that's where I
would expected that you would have, and it's not a big deal. And the lawyer said, no, you can't send it to me. So you would have had to send it to her, and you would have had to adjourn it probably to get her proper notice.
Yeah. So basically I had to refile a motion. So, and that was just for the money from the marital house. That was the first motion. That was back in June. I didn't make this motion until I had to be able to get her to school, to TK, to Millville.
Have you ever talked to your daughter about whether or not where she wants to go to, and is she upset and this kind of stuff? Because there's a practical issue that how am I supposed to fix it?
Absolutely. And she's miserable down there. She is.
He's not. I have texts of brainwashing that he's been doing to her, and she did have a talk with him at first, and she told him she was okay with moving down here, and that's when he feel bad about her decision.
Your daughter at school right now?
Yes, and she's actually we talked to her. Then she had a real good day yesterday, starting to meet friends, and has a boy crush already.
What time did she get out of school?
At 2:30.
Where do you live? Edwardsburg? How long does it take you to get here to court?
It would take me an hour and a half.
All right. When did you talk to the people? See, the problem is you waited too long no matter what, because we would have been hard pressed to get you in, even to give you the chance to move your child, because we aren't just sitting here waiting for people to come in and ask for things. We gotta have an evidentiary hearing.
That's what sucks, is because I didn't know that. I'm looking right now when I went there.
I understand, and I'm not holding it against you, but you also have to understand that you gotta play by the rules. And because you don't know the rules, doesn't mean that you're exempt from them. Okay? That's why everybody is supposed to hire an attorney, because they know the rules. And I can't imagine Ms. Giordano saying, no, you didn't have to file a motion to change down to there. I don't have any idea what would have been in her mind to do that.
I think I actually have an email of her stating that, because she asked, you said, do you want to hire me? I said, what do you think? She's like, I don't think you'll need me for this.
That was for that first one.
Yeah, talking about.
All right. I'll figure something out on this over the next few minutes, I guess. As far as the money for the house, you don't think you owe him anything?
No, I have actually, he owed more and I gave in to him.
You gave it.
I gave as much as what he should have owed back. I didn't give back. I let that go, and it's in our text even. And I told yes, we have text before I cashed that check with him, because we're going to go to court if he was not agreeing to the amount. I was not going to cash a check until we had an agreement of what was owed after calculations through the court papers. So I made a statement. I said, Mike, before I cash this check and send you over this money, is it reset? Is this what, do you agree on this payment, this payout? He said yes.
Never said.
I have a proof of that too, if you need me to send you the screenshots of that conversation, sir.
We're gonna have a hearing on that. You can bring your stuff in. If it's found that you owe extra money, I'm gonna fine you for it. If you find whoever's gonna lose is gonna pay the other person's attorney fees, because this is a straightforward amount. It looks like you got 50, just for round numbers, like you got $50,000 from the house. Medical bills were some, I don't know, 2,000, and also you were owed, ma'am, apparently about 8,000, which would take it down to about 39,000, and you were supposed to split the rest. How's that not correct?
So it was 8,000. If you look at the court papers, what's it? 2,000 first out of the house sale before we split money. I got first before we even split anything for me from miscellaneous expenses.
Yeah.
And then after that, it was
It's in your judgment, and I can read it to you.
Thank you.
Plaintiff shall receive a total of 8,100, which represents money defendant owes to equalize the value of stock in his name, the automobile, past due child support, and 2,000 owed to plaintiff for miscellaneous expenses. That's within the 8,000.
No,
That's
that's
what it says.
then I can contact her to contact you. No, the 2,000, he knows what I'm talking about too, because I even have the text with him breaking it down, extra 2,000.
Okay, even if he owed you that 2,000, you still haven't paid half.
No, that 2,000 was supposed to be before we even deducted any of it out of the house sale. That was the 2004. And then after that is when we divided what was left, the 47 after that.
47 after that, and you paid, and he was supposed to deduct 8,000 out of that, so that came down to 30, I don't care, 38,000, okay?
And then go down here, the party shall divide remaining profits equally from defendant's portion. He shall pay plaintiff additional 220, which presents his motion portion of the late fees for the rent.
That's $220. Basically, you got 38,000 to divide in half.
Yes, and then it goes on. And then on top of that was the defendant shall also pay the 240 from the check he wrote, which was actually 280.
Yep.
He left one.
Okay, but it's in the judgment of 240. So I'm down to, I don't care if I go down to $37,000 and it's split in half.
It still goes. And then we had medical bills we had to deduct.
Those were already deducted. They were
No.
1,900.
That was deducted from when?
That was in his calculations. He's already got those deducted. 1,700 in medical debts.
Yes, that was not part of the 8,000. This was because we didn't have
I
that
understand
amount.
he deducted it also. All I'm saying is it looks like it's about, even with taking all your money into it, is $37,000 divided by 2, which is some 17, and you only paid him 13.
No, 14. And then, but there's more deductions.
13 for 36.
And then we both owed for the divided what we owed after the bank, after his check that he wrote from withdrawing from the bank, we had to divide in half the remaining balance of what that bank statement was that we owed.
We're going to have a hearing on it. I'm not buying what you're saying right now. We'll see what happens. I'll set up an evidentiary hearing. You better either have attorneys or better have evidence, and you better follow what it says in the evidentiary hearing document. It says file your documents and stuff ahead of time. And ma'am, if one of you is wrong, I'm gonna burn you.
Okay, I have it all right here broken down twice now.
Nothing you've told me would be convincing as of right now, because it's 100 here and 200 there, and basically there's 38,000 that has to be divided. And
Oh, yeah. There's the text, and then like on here too, it says he's owing $100 per month for his phone bill. He has not paid his phone bill since May.
I had to get my new phone because you shut my phone off. So let's,
I finally shut off in August when you weren't paying me
that's
still.
that's not in here.
has nothing to do with any.
It's in the it's F in section F.
Your Honor.
Yep.
So I didn't know how to ask. I would love to have our 16-year-old daughter's voice heard in this,
I'm gonna tell you what I'm gonna do here before too long on that. Okay, I'm setting up an evidentiary hearing on the amount of money that's owed.
Okay.
Because I'm not gonna be able to fix it here, because she says one thing, you say another. Looks pretty straightforward in the judgment. Like, there's nowhere near the amount of money that she's claiming she'd get. I'm just telling you, but I don't know, maybe she's right. As far as your daughter, she goes to school on Monday, I'm sure.
Yeah.
Have her here at my courtroom by 4 o'clock today.
Okay.
Today, I can't do today.
Oh, sir.
What is it you can do to follow any of the orders? That's what I'm trying to figure out now.
Well, it is my weekend, Your Honor, and I'm driving an hour and a half to pick them up, but our youngest, Sophia, doesn't get out of school. She won't get home from school until about 4. So I was planning on leaving here at 3 or 2:30 to go down there and pick them up by around 4. But then I won't get back here until.
Yeah, you won't be back here till 5:30. I don't know how it is that I'm going to talk to your daughter. How am I going to talk to her?
We could do a Zoom call after she gets out of school today, I guess. I'm not sure about today unless I go down there and get her out of school early and then.
But then you'd have to drive up here and drive back and pick up your other child. And
yeah.
Here. I'm gonna set up an evidentiary hearing on what's called a Lombardo hearing on changing of schools. I'll have my clerk contact you as far as contacting your daughter, trying to set something up. May have to be via Zoom at some point. How long do you have her for this weekend, sir? Just till Sunday?
Yes.
I'm gonna set up something via Zoom. I don't know what. I'm not sure how I'm gonna do it.
Okay.
Set up a Zoom call with your daughter where nobody will be in the room with her, just me.
Yep.
And if I find out one parent or the other is trying to influence them, it is not gonna go good for you. This is a very troublesome thing to me. And if one person or the other is trying to influence her to pick a school or something, it will not go good. I'll tell you that at the evidentiary hearing, it will not go good for that person at the evidentiary hearing at all.
Understood.
So I could have a Zoom call with her Monday. I take it right after school.
Yes, she'll be here.
I'll have my clerk contact you to set it up for Monday. Mr. Bauma will let you know when it is. You aren't gonna be allowed to hear what I'm gonna talk to your daughter about. It's gonna be between me and her.
Yep.
Ma'am, you understand the rules? I'm telling you the rules, not the clerk.
I do now.
All right, that will set up some hearings for you. Good luck. We'll see you.
Sir, after your talk with her though, will we have a hearing still too? I just want to know all your.
We're gonna have a hearing unless Mr. Bauma and you agree to where she can go to school. I gotta have a hearing.
Okay,
We're gonna have a hearing about the money that is or isn't owed.
okay. I'm gonna plan on getting a lawyer.
I would suggest both of you do. I mean, this is not.
Yep.
I actually suggest two of you act like adults and figure it out, but that isn't gonna work, so we'll have evidentiary hearings. Good luck.
Thanks.
Amanda, you need to turn on your audio.
I don't think she can hear you, but.
No, I was thinking that was
Because she has no audio, so she can't hear you.
Yeah, I was thinking that was her mic, but I will,
There she goes. Miss,
there she
Emma,
is.
Can you hear me? And if so, I see you're saying yes, just so you know, you're muted at this point, so you need to unmute if we talk to you. This is the case of the Ross. Both parties are present via Zoom, as well as Mr. Grabowski on behalf of Ms. Hamlin, the plaintiff. This is the father's motion for parenting time, just as he wants 50-50. Just because you want 50-50 doesn't mean you get 50-50. What's Vadvarka to change any of the current situations, or what are you asking for? How much do you visit now?
We have parenting time established between the two of us that I have an audio recording of. And Miss Majeski cut my parenting time without any explanation as to why.
What's in the court order?
We don't have a court order.
Okay, so you have some kind of a recording from when?
From my and Miss Majeski's meeting that took place back in May of 2023.
Doesn't mean anything unless you put it into a court order. If you have an agreed stipulated order, then it's one thing. I can't enforce something that you guys just talk about.
It was us going over a court order that we were supposed to be getting documented that never was documented.
I can't enforce anything. What is your current parenting time? What do you exercise right now?
With my daughters with Majeski, she doesn't allow me any parenting time.
When was the last time you saw him?
I seen Desiree last week, and it would have been last August. I don't know.
Over a year before you saw one of the others?
No, it was June, back in June of 2023.
Well, just apparently she has physical custody at this point. All right. And you have to, in order to change custody, you have to show proper cause or change of circumstance. What is that proper cause or change of circumstance? Because she clearly has an established custodial environment and has done everything for the kids forever. Okay. What is the change of circumstance to change custody? Because you're a 50-50 is not parenting time. That's a change of custody.
Okay, Your Honor, I don't know how the legal system works. I'm just trying to.
I just told you how it works. I just told you how it works. Okay.
You're right. I said.
So there is no proper cause of change of circumstance to change custody.
I'm just
I have allegations that you only visited for 3 times as of 2022, I think.
And that is false accusations. I have recordings, documented proof of my visitations with my daughters.
Frequent?
The frequent documentation from the recording.
Frequent visits you had over this is a case that's a 2012. So I'm assuming that, I mean, your kids are 14 and 11 and you're talking to me like, yeah, you saw them every other weekend. You saw them every week. What?
I seen them for about 2 months every week. And then Miss Majeski stopped the visitations.
2 months every week. What do you mean 2 months every week?
I seen them weekly for about 2 months. Their practices, through Zoom calls, FaceTime.
Mr. Grabowski, what's your response?
Well, our response is laid out in our response, what we filed. I apologize for the lateness of that.
I understand.
But in a nutshell, what Mr. Ross is speaking of is since during the summer, there were some limited video chats. We were in front of you, I believe, just about a year ago when Mr. Ross filed for change in custody. At the time, you informed him similarly to today, there hasn't been any change in circumstances or proper cause shown. So you suggested he work with me on establishing some parenting time because from 2012 until last year's hearing, he had seen the girls 3 times briefly. And so we did work with that, and I presented my client with a graduated plan, and she went over it with Mr. Ross. They met and agreed to try it out. And it started with some Zoom meetings with the girls.
4 weeks or something like that.
Yeah, it went well. Actually, the Zoom well, exactly, it was for 4 weeks, but the Zoom meetings, I think there was 2 or 3 over the course of 3-4 days. And Mr. Ross would say hi to the girls, and then he'd turn it over to his stepkids or his girlfriend's kids or his girlfriend.
That is false. That is false.
If I may.
Sir, I'm gonna warn you only one time. He didn't interrupt you once.
I'm sorry.
You get your chance. If you interrupt him again, I'm gonna mute you and not be very nice.
I'm sorry.
Go ahead, counsel.
So Mrs. Hamlin contacted Mr. Ross and said, hey, this is, your kind of time, not for all these other people. And as our response says, things went off the rails immediately. Mr. Ross and his girlfriend showed up at the girls' games, which was okay, but things didn't go well. The day after Des, the oldest daughter, spent any time at all with Mr. Ross and his girlfriend, the next day she was suspended from school for the first time ever. Conduct totally out of the norm. No idea where it came from. Des was received some counseling. Mrs. Majeski got her some counseling through Newaygo Community Mental Health. That went okay. There was allegations from Mr. Ross. He contacted my client and said, look, she's suicidal. We think she's suicidal. My client took Des, the supposed suicidal girl, to Pine Rest, took her directly there and had her looked at and said, does she need to be in here? Does she need to be admitted? Is there anything? Pine Rest told her, there's nothing here, and sent them on their way. We have found out that Mr. Ross's girlfriend has been, and Mr. Ross a little bit, but we believe it's mostly his girlfriend, has been surreptitiously seeing the girls behind Mrs. Majeski's back.
That's a lot of.
She's contacted the school and said,
there's a lot of allegations about her seeing the kids and stuff like that at the school or that kind of
yeah,
stuff.
she called the school and said she was their mom.
Yeah.
Told them not to take the bus home, and she picked them up. Just improper.
Yes,
This is parenting time for Mr.
Sir, if
Ross.
you know that is happening, and I'm sure you're going to deny it, but if you know that's happening, that will not happen. Will not happen. If your girlfriend shows up and picks up the kids without the agreement of Miss Hamlin or your parenting time specifically, and she shows up and interferes in any way, shape, or form, not only will I prohibit her from being around there, but I'll take that into consideration in any of your time that you're going to visit. This is your kids, yours and Miss Majeski's kids, not your girlfriend's kids.
I know that, Your Honor.
So,
Mr. Grabowski, I'm going to eventually, Mr. Ross is going to get a chance to start having parenting time.
Yes,
He's
we
not
agree.
going to be a change of custody. He's not going to get 50-50 because there is no proper cause or change of circumstance, but Mr. Ross is going to be able to get some type of parenting time. What type of parenting time do you suggest at this point?
Well, at this point, we, as my client met with Mr. Ross this summer and they worked out this graduated parenting time, and as Mr. Ross himself says, they reached an agreement on it. It's just that within 2 or 3 days, Mr. Ross decided he didn't like the agreement anymore. I think that was appropriate for a dad who hasn't seen, well, the youngest, he left when she was a baby. He's got absolutely no relationship with her. As our response indicates, the oldest, Des, who has, she has an IEP at school, so she has some issues. She is scheduled to start counseling with a Mr. Hyde, and we detailed him in our response on the 18th. My client has been trying desperately to get her in to see someone like Mr. Hyde, who has a great reputation in that.
Why don't I send this to the friend of the court for a parenting time evaluation? See what
That would be certainly very appropriate, Your Honor.
I'm going to send this to the friend of the court for a parenting time review. They will interview both of you unless you decide not to, in which case they'll only get one side. And they'll make a recommendation as to what's appropriate for some type of parenting time. Do both of you work?
I do, yes.
Well, I don't. Because it's a cost of $150 per person to go to the friend of the court. Is there any reason you can't afford that?
No, Your Honor.
No.
All right, then we'll split the cost, $150 each. You'll be paid, I believe it's within 14 days. You'll get notice of it. If you don't pay it and the other person pays it, it's not going to go good for you. I mean, I sit here, I'm the one who makes the decision, and you just both told me you can pay it. Now, if you don't pay it, you're going to come back to me and say, why? And you got to understand, I'm the one who's going to make the decision on the parenting time ultimately. And I don't know why you would want to tell me you're going to pay it and then not pay it. Okay. I'm going to take that as credibility. So you will each be responsible to pay that. You'll each be responsible. The friend of the court will contact you. They will talk to you. They will do whatever is appropriate. And we'll get a report from the friend of the court. Cooperate with them 100%. They'll send out a report. You get a chance to look at it. If you don't like it, you can file objections to it. Mr. Grabowski knows how to do that, but I'm just talking to you, Mr. Ross. If they make a suggestion and you don't like it, you can file for a objection to it. We'll have a hearing and all that kind of stuff. All right. Work with the front of the court. They'll try and get to the bottom of things. It probably will be some kind of a break-in time. I don't think they're gonna probably just say, oh, no, I'll go to every other weekend or something like that. But I certainly trust their abilities to review everybody's situations. You'll get a chance to provide what they talked about. They do this all the time. Any questions, Mr. Ross?
No.
All right, Mr. Grabowski, Miss Hamblin through Mr. Grabowski. Any questions? She can always ask questions of you.
Right. No, we don't have any questions, and we appreciate your time this morning.
And you got to cooperate with the front of the court, sir. You got to cooperate with the front of the court so I can get a better idea of what's appropriate. Well, they'll take into consideration kids' special needs and all kinds of stuff. Good luck. We'll get that. We will do the reference. You don't have to do that, Mr. Grabowski.
Okay, thank you.
Okay, make sure that you pay when you're supposed to, and we'll get that notice out to everybody as soon as we can. Good luck. Have a good weekend. Thank you.
You as well.
Brian for plaintiff mother, Ms. Van Tol for defendant father. Starting to become frequent flyers in the court, and I am well familiar with this case. This is a motion being filed by Ms. Van Tol on behalf of the father for a change of custody, going through, I don't know how many pages of 16 pages of complaints and whatnot of what a horrible person mother is. I got an answer from you, Miss Bryan, telling you what a great client you're and what a deadbeat the dad is. That pretty much summarizes it as far as I'm concerned. Miss Van Tol, this is, I'll tell you right up front, I believe there is plenty of proper cause or change of circumstance to look at legal custody. These parties don't get along. I don't think they could agree if that today was Friday. So I think we should have a hearing about legal custody. The only question is, what do I do about physical custody? Miss Van Tol, go ahead and make your anything you want to add. I mean, I've read page after page of this garbage.
You know, Your Honor, I understand the court's frustration with the continued issues in this case. Ultimately, I think the issues revolve around an inability to move on. And I'm just not sure how we can impress upon Ms. Ludwig to move on. My client doesn't want to rehash the past. He wants to move forward.
But he doesn't, but you do in this motion, you rehash the past.
Well, we have to. I mean, right? We're filing a motion to change custody. The motion to change custody is necessitated by the fact that Ms. Ludwig continues to stalk my client.
Is it necessitated by the guy who isn't even part of this, who says, I don't even know these people, and you're getting a PPO against me because you think you're doing this?
Sure. So let me address that. I'm happy to address all of those things, Your Honor. So thank you.
You're not going to address much of them here today.
Sure. The PPO was filed. The PPO was supported by my client's statements, the neighbor's statements, and the statement of Miss Meager's friend, who also witnessed this gentleman in Ludington in the summer of 2022 taking pictures of my client's child and Miss Meager on the beach. My client approached this individual. He's looks very similar to Mr. Thielen. Okay. The issue in this case ultimately stems around Miss Ludwig has told Mr. Ludwig over our family wizard since January of 2022 that she has people watching him. She has a coworker living in Miss Meager's neighborhood that's sending her pictures of my client's vehicle at her house. She then goes ahead and tells Mr. Ludwig that she hired a PI, sends him a bunch of messages in March of 2023 showing pictures of my client and the child, vehicle information. Every single thing has continued on because Miss Ludwig can't move on. And that is a problem. This is not just the only issues, right? We have the issue at the baseball game where Miss Ludwig shows up. She makes a huge scene in front of the minor child. I have video of it, Your Honor, and I'm happy to provide it to the court. Miss Ludwig does reach over the back seat or over, well, I shouldn't say back seat.
Well, look, I'm going to tell you right now that Miss Ludwig's apparent being drunk at a kid's baseball game, we can get rid of all of that, and neither party can show up at the other party's times, okay? So that he can't show up when she takes him to baseball games and he can't show up there. That's the only way I can keep these people apart.
But is that really what's best for the minor child in this case? Because he wants his dad to come to his events. But whose fault is that?
Parties can't get along.
Whose
I'm going to have a hearing. I don't know.
It's not my client. I can tell you I've seen the video. And ultimately that's an issue. And I don't know what to do about it other than she can't be calling my client and his girlfriend names in front of this child where the child's then having to say, don't talk to my dada that way. Don't speak to my dada that way. That is horrible. What is my client to do? She gets out of a freaking car at an exchange last Friday, starts taking pictures of his vehicle and the boat that he has attached to the vehicle. Again, just to spur controversy. She shows up at Metro Women's Health. She has no idea my client's there. I don't even know how she knows this summer, and leaves Crew's sippy cup right outside his door just to let him know that she knew he was there. Then she messages them on OFW saying, how are we going to speak to Crew about the fact that Mandy's pregnant? She's not pregnant. She is obsessed with my client. I don't know how to get over this because it is impacting Crew, who is now in play therapy every week. And I understand she wants to say it's because my client alienated, but that's not the case. My client
Well, you
hasn't.
know,
Miss Judd didn't find it.
I'm going to give Ms. Bryant just a real short time to respond because I basically know what I'm going to do.
Okay.
Ms. Bryant, I'm sure you're going to deny a lot of this stuff and say that, you know, a lot of it's untrue and blown up and all this kind of stuff. I mean, I read 25 pages. Okay. If everybody submitted this much on 40 motions for today, I wouldn't have even been able to read it all, let alone have a hearing on all. And so you can respond, but my opinion is, after reading everything, is that definitely we need to have a hearing on joint legal custody, because I think that is clear that there is proper cause or change of circumstances, because these people cannot get along. Okay, they are not going to be able to make joint decisions together and for the best interest of the client. I don't know who will end up with the legal custody. I have no idea. Okay, and I think as far as proper cause or change of circumstance for physical custody, I intend to have an evidentiary hearing to determine if there is proper cause or change of circumstance to move forward with that. You can have a threshold hearing that I will set in here and determine if in fact the threshold is met. If Miss Ludwig is doing half the stuff that she's alleged to have done, I'm probably going to find that we'll have an evidentiary hearing regarding custody, but I'm not going to determine it right here today because I get so many things going back and forth between everybody. I'm just going to have an evidentiary hearing to determine if threshold is met. And then from there, if threshold is met, we'll have an evidentiary hearing on custody. But
my only concern about that plan, Your Honor, is that when you do the threshold hearing on the change, I'm sorry, on whether there's a change of circumstance or proper cause, these parties are going to dig in both ways. And, you know, we'll have our claims, he'll have his claims, and it's just not helping the child.
No, I mean, but I can't do anything else. I'm not gonna, my only other choice here is to say there is or is not threshold is met. And I don't trust, I'll be honest with you, I don't trust either party very much.
I think the court has the ability, based on the pleadings filed in the response, to determine whether there is a threshold change. For example,
I do have the ability to, but I'm choosing to have evidence brought in, and I'm not going to have a long hearing. I'm going to tell you right now, you're going to come in and present, because I don't have time here today to really go through all this stuff. And I thought about giving you guys a separate time to really go through this, but I got 40 motions today, and I just don't have time to go through all this. So I'm going to have a threshold hearing. We're going to have a short threshold hearing. It might be an hour, it might be 2 hours. And believe me, counsel, we will meet beforehand to find out what kind of documentary or exhibits or something like that is going to put in. We're going to figure out what is going to go in and what isn't, what there's an objection to or not, and maybe decide who the witnesses are. We're not going to go through a custody hearing. We're just going to go through a threshold hearing, and probably each of the parties can testify. And I'm going to set limits on this. Okay, I'm just warning you right now, and then we'll see what happens. And then I'll make a determination whether there is or isn't threshold. You know, I've already found the threshold on legal custody.
Is the court going to refer the matter to front of the court for the issue on legal custody?
Nope.
Okay.
Because it'll just take time for them to go over there, and I guarantee you that whatever the front of the court finds, the person who isn't happy with it is going to object, and I'm going to have the hearing anyhow. I guarantee with the two of them, and there's just not, if they say legal custody should go to Mrs. will object, and vice versa. I know that. So it'd be just pushing it down the road extra months, so that then I push it farther down the road. At the rate we're going, we won't get through custody and everything till January, because I got to but I can have a relatively quick threshold hearing, and that's, believe me, that's relative to something, because I'll probably only give like 2 hours or something, one to each, but we will meet ahead of time to get through stuff that's appropriate. All right. I mean,
Thank you, Your Honor.
that's the way it's got to go in this case. And I'm probably going to wait and set up the legal custody determination after I have the physical custody threshold hearing so that I know what's going on with that. But we will have an evidentiary hearing ultimately regarding legal custody because these parties cannot get along.
And Your Honor, if the court finds that the threshold is met, will the court grant leave to allow us to file our own motion for change of custody?
If threshold is met for custody, okay, you don't need to file one because it's a custody hearing. I mean, people have made mistakes before and filed for custody and actually lost what they think they were going to get. Once custody is an issue, I'm not going to say that he can only win. It won't change. If you, during that whole time, show that custody should be with her, I don't see any reason why I can't change it to her.
Right. Thank you.
Anything different, Ms. Van Tol?
I don't. I think custody, if it's in dispute, it's in dispute. I get that.
If I find there's a threshold, I think it's in dispute and we will do all the custodies then and figure out where all custody should go.
Got it.
All right. So I'm telling you right on the record, you don't need to file unless I suppose if I find there is no threshold, and then you decide you want to file and say there is threshold, which won't do you much good. But I'm assuming that everybody's going to try and find threshold, that the two attorneys need to sit down and talk about as much as you can on this to streamline this stuff. All right. Because we're going to be at this forever. All right. And both of you need to talk to your clients and be realistic about some of this stuff. You both know what you're doing. Right. And ma'am, you need to listen to Miss Bryan and Mr. Ludwig. You need to listen to Miss Van Tol. Seriously, listen to them on what's going on. If you because this child is 3 years old and is in therapy. That is awful. And I don't know whose fault it is. It's probably some of everybody's fault. So figure it out. We'll send out notice about the threshold hearing. I'm going to hold off on setting the legal custody hearing. I will find there's threshold for that. If somebody wants to file an order that says the court has found threshold is met for legal custody, you can do that. But I'm not going to set that right away for the reasons that I've told you. I think it's appropriate.
Your Honor, is it possible for your clerk to reach out regarding scheduling of this before?
Absolutely not. She's going to set it and hope that you guys are around.
You said set notice, and I was like, well, maybe if we can get, some advance.
We're going to try and make it impossible for both of them.
Thanks, Judge, I appreciate it.
I'm assuming that you will check with your clients promptly to see if they're going to be out of state or something. We will check with you. I'm going to tell you that Miss Dewey gets really tired of checking with one and another, and one person can do this and one. If you get it, you're going to get about 2 chances, and then she's going to set it. But we will really try to accommodate your schedules. It'll probably be a morning or an afternoon for the threshold. So
okay,
we'll do the best we can.
I appreciate it.
And believe me, she will work really hard with you. All right.
Thank
Anything else?
No, thank you.
All right. Thank you very much. Have a good weekend. Zoom. We have Mr. Volmering on behalf of the, let's see, I got to make sure I got it right. Plaintiff. That would be Miss Singer and Miss Bryan on behalf of Mr. Singer. This is a motion basically to allow the kid to play hockey. That's the long and short of it. And my real question to both attorneys is, did the kid play hockey last year?
Yes, Your Honor.
Miss Bryan, he did play hockey last year.
He did, and that was
Is
before
he playing any other sports right now?
Not to my knowledge.
He's involved in a number of activities through Egypt Valley. And at least when he is with Dad, he is doing all of those activities and sports through Egypt Valley.
Meaning golf?
I'm looking for Dr. Singer to nod for me. Does he? Yes, he's involved in the junior golf program at Egypt Valley. Again, only when at Dad's time, because Mom did not allow that.
All right. And Miss Bryan, I'll just ask you up front, why he's not going to spend every afternoon from 4 o'clock till 8 o'clock reading and studying. I understand he's not the best student. Not all kids are the best students. I understand he had some school problems and almost wasn't going to pass till the 3rd grade and things like that. And I'm a believer that kids should, if they want to play a sport, they should play one with the understanding that they better keep their grades up. At least that's what my kids, if they didn't, that was a hammer that I used for him to make sure that, you screw up. And I can give you an example of my son being terrified to tell me he got a D, but it wasn't really the right grade. And he knew I was going to make him get off the sports team because of that. And I gave him 1 week to make sure that it was corrected, and it was. And I don't think I think I was a pretty nice dad, but he was terrified because he knew that was going to require him to get off of sports. So I'm inclined to allow the young man to participate just because he participated last year. And it's not, it isn't even as extensive as after school from 4 o'clock till 6 o'clock every day, like maybe football or something like this is. I understand it's twice a week, probably practice. Where are the practices to anybody who knows?
Patterson.
Patterson?
Mm-hmm.
And I understand that with hockey, you'd have to get him there a little early. He has to change. He gets off the ice. He has to change. It's not just an hour, because even if it's an hour, it's usually 50 minutes, I think, because then the Zamboni goes for 10 minutes. And at the same time, it seems to be a good outlet for somebody who has anxiety or whatever. Miss Bryant, I'm kind of tipping my hand, and I'm going to go to you because Mr. Volmering, as you can tell, I'm kind of leaning in that direction, and I am loath to make these decisions. I mean, I'm the parent who should make a decision whether their kid should play hockey or not. This is kind of ridiculous, but I kind of think, even if it wasn't hockey, I think it's great that he's involved in golf out there or something too. But if your argument is that he should spend more time with studying and things like this, then I think you'd take him out of golf, because that takes time away. And I don't want it. I don't want him to. I want a kid to grow up and have sports and things like that. And I just think it's not overwhelming. So, Miss Bryant, you might be swimming upstream, but I'll give you a chance.
Okay, I'll start swimming, Your Honor. It's one of those cases where you look at all of the facts. And last summer, Dad was trying to get all of the kids involved in the different Egypt Valley programs and things like that. And that I mentioned in my response, the Michigan Sports Authority thing that Mom had agreed to, and then she wouldn't facilitate any of their attendance. Even in that situation, she had agreed to. So now he played hockey last fall. I'm holding in my hand the child's IEP, which is dated May of 23, and it talks about all of the child's deficiencies with regard to school. I think you make a good comment about how you raised your son, and if you have bad grades, you don't get to participate. And I think that's what Dr. Singer's primary objection was. It's like, hey, we got a kid who is regularly testing below average. I'm looking at 9th percentile, 16th percentile, things like that, that we need to prioritize academics and create a carrot, so to speak, before you get the privilege of participating in these activities. But what happened here is that even though Dad was talking about that and they were having conflict with regard to transportation, things like that, Dr. Singer said, you know what, I don't think it's going to work out this year. And not that it's a permanent thing. Remember, this is not a child, we're not talking about high school hockey. It's just, a young person's extracurricular activity, just like golf was, just like, all the other activities were. But Mom didn't participate in any of those, even though she had agreed. And now all of a sudden she files a motion on the one that she wants. The other context of this is that when we filed our response to this, then Mom is bad-mouthing Dad to all the kids about Dad this, Dad that. And the whole context of it is more of a power struggle than it really is about the child. So now, although we respect the court's opinion on this and we'll abide by what you say, but there is definitely more to it. And we don't think it's harmful for this child to pause on one season, kind of get back on track academically. Those other activities that you mentioned, like golf, things like that, that was the summer activity. Those were the junior programs that took place in the summer. They don't take place in the fall. So maybe if we were able to prioritize things,
more time with him in the summer doing studies and stuff like that. I fully agree with both parents. I think Dr. Singer is correct in having him involved in golf. Okay, I think it's a great. Just because I like it doesn't mean it's for everybody. But I think it's a great lifetime sport. Okay, you can play it all your life. I mean, I'm still playing it, and I'm 100. And so it's a great thing to be involved with. It's kind of like swimming. It's a great thing because you can swim all your life. You can't play football all your life. I can tell you that. You probably can't play hockey all your life, but it's a great sport to be involved with. I think some of hockey is really good with that. You get, I don't know where you play your games, how far away, whether you play in Muskegon or Lansing or whether they're all local. I mean, this is not a travel team. Okay, I'd look at it different if it was a travel team, because then it's weekends and everything spent away. And you're going to have a lot tougher time, Miss Singer, convincing me about a travel hockey team than you are a local hockey team. One of the problems is if you take them out of hockey, you can't miss very many years before everybody just zooms past you. You just can't. I don't know what else to say, but I mean, I've seen kids who you can't join hockey at a later time and hope to play with kids who've been playing for 5 years. It's just, I mean, they'll just run circles around you. And so I think it's a sport that is fine. I would like the parents to actually talk to each other to the point where they say, if, I think it's Jacob, is that his name? If Jacob isn't performing at school, if he isn't doing, maybe you tell him you got to read extra on the Monday and Wednesdays because you play hockey on Tuesday and Thursday. And if you're not going to do this, then the parents need to parent just as they would if they were together. Because if you were together, you would probably say, okay, but if he's not doing his homework, if he's not getting better, if we need to find a tutor for him or something and that interferes, then that's something different. Okay. But him having played last year, I would just like to see him get the opportunity with the understanding that these parties can parent, co-parent, and put appropriate things in. Ma'am, if he's failing his classes, I would expect you'd say, Jacob, you're not going to play hockey. Because if it comes back to me, that's what I'll say. Jacob, you're not going to play hockey. Okay. You use it as a carrot. And Miss Singer, you do have to, if he wants to have him in golf or something like that, there's no reason that you shouldn't in the summer or some of these things, because you are asking for your sport. And if there are other sports in the summer, things like that, I'm going to give Mr. Singer his sports in the summer or whatever. All right. It's very frustrating to me when I see two people who now suddenly go to their own corners and fight about this stuff, when if you were still together, you would figure stuff out. Okay. And why it is that you would think that it's a good idea that I decide whether your son plays hockey or not, or whether he plays golf or not, I can't figure it out, but I'm here to do that. I don't think there's any factual disputes that I need to have an evidentiary hearing on. Would counsel agree to that? I mean, in theory, if there's factual disputes, I'd have to have an evidentiary hearing on this. But
the only thing I know of, Your Honor, and my client texted me when you made the comment about this being local, is that there are a few games that are out of town. But I want to be respectful of the court's opinion. We're not going to have an evidentiary hearing on this. We'll abide by the court's view. And I especially appreciate the comments about facilitating the sports that Dad has suggested going forward. And I think that will do a lot to resolving disputes in the future. And if necessary, we'll take action through the courts if it doesn't work out. But I hope that it will work out. And I hope that your comments to the parties will be effective.
I certainly think you know where I stand. And if the parties don't understand where I stand, then, and I'm not, and just addressing out of town, I'm sure there's a tournament here in Mount Pleasant or something like that. I know enough about kids hockey to tell you things about it. There might be one in Detroit, there might be one in Chicago and stuff like that. But I'm talking the difference between a tournament somewhere later on in the year versus travel hockey, which I know about travel hockey, where I'd spend weekends in Nashville. That's a different world for a kid who's not doing good in school. And if the kid is not doing school, the two of you better decide, ma'am, you better say, I think you're gonna have to sit it out, Jacob. All right.
That's helpful. And Your Honor, I don't know whether this is going to happen, and I don't know when the games are, anything like that, but I would think that if Dr. Singer and his family have plans like out of town travel for something, that would take priority over a routine hockey game. He's not going to intentionally do
There's
that,
no
but I
such
just,
thing as a routine hockey game. I mean, for Pete's sakes, it's like saying there's a routine golf match. There are no such things. Those rank higher than anything. Okay. Now, I'm saying that jokingly.
I would
Parties need to work together on this. Okay. And I would imagine Miss Singer is going to probably have to do some transport of him sometime. And you have to do that. And Mr. Singer, you don't worry about her doing, you may have to do some transport sometimes when Miss Singer can't, if it's on her time or something. You maybe are going to take turns in taking him to, I'm just saying Mount Pleasant because I have no idea, but Mount Pleasant for a hockey tournament, and it's her weekend, but it doesn't work out for her, and you may want to go. You should divide it up. I assume, Mr. Singer, that you probably like watching Jacob play hockey. You didn't think it's the best thing for him, but just like you enjoy watching him, I'm sure you enjoy watching him play golf. I enjoyed watching my kids play whatever. Well, one kid, the other kid didn't want anything to do with sports. And my youngest could not play enough sports. And so it's just how you have to work together. And I was divorced, and my wife and I worked on making sure the kids were there, and we got to go to some of the fun tournaments and things like that. And maybe you have to step back, Miss Singer, and not take him to a tournament so that Mr. Singer can take him there and stuff like that. Work as if you're parents and that you don't want me to be the parent. I'll go watch him play hockey or play golf. Those are two of my favorite sports, even though I'm no good at hockey or golf, quite frankly. But I want you to work together, talk to attorneys, get their advice, but work together. Would you please? I'm getting every shake of everybody's head except Dr. Singer. He's not buying anything I'm saying.
no, he's nodding.
I'm just kidding.
Oh,
Mr. Volmering, I've stolen your thunder. You've done what every good attorney when they're winning does, which is sit there quietly and say nothing. Is there anything you wanted to add just so you can have your voice recorded?
The only thing, well, no, actually, Your Honor, no. I'll just shut up.
Good idea. I got 40 motions today and I don't really want to hear from you, but anything else from you, Mr. Volmering?
No, Your Honor, thank you.
Anything else from you, Ms. Bryan?
no, Your Honor.
And I appreciate your comments and stuff. And I hope that the two of you will just kind of sit down and maybe talk to your attorneys, maybe all four of you talk and kind of figure out how this goes and things. Come on. All right. I'll be the super parent, but I don't want to be.
Very helpful. Thank you, Your Honor.
Good luck, everyone. You can draft an order if you want. Can both of you hear me?
I can.
Yeah, I can hear you.
All right, this is versus battles. Both parties are present via Zoom. This is father's motion for parenting time. Says he just wants to establish fair parenting time. Ma'am, what's some fair parenting time for him?
He's always been able to take them. The problem is he doesn't show up. So
Well, I'm going to order some time. What's a fair parenting time? You could have every weekend or what?
I feel like we should do half and half. I feel like we should do like 1 week on and 1 week off. Then he can have as much parenting time as I have.
Oh, that's pretty big. That's pretty kind of you. Mr. Battle, what's wrong with that?
Nothing.
All right. When do you guys want to start that?
We can start Sunday.
Can the kids get to school from both parties' houses?
I currently get them to school, so
You guys will figure that out?
I don't know. Okay.
Mr. Battle, you'll have to get them to school.
We'll figure it out.
All right, then we can do exchanges do you want to do them like Sunday at 7 o'clock at night or Monday or what do you want to do for time?
Sunday to Saturday, 8 p.m.
Well, if it's week on, week off, it'll be Sunday to Sunday.
Okay. Yeah. 7 is fine.
Does that work for you, Mr. Battle?
Yep.
And they'll go to Mr. Battle this Sunday or next Sunday?
Next Sunday.
Yeah, I would just soon as start next Sunday because you're gonna have to arrange everything. The kids don't know that they're going there right now.
Yeah.
Okay.
Start it next Sunday, okay?
Okay.
And we'll get an order out that starts at 7 o'clock on Sundays. Good luck, everybody. Thank you. That was, that's a nice solution. The kids get to have as much time with you, sir, as they do with her.
Yes.
Jacobs,
Will-
both parties
will
are
we
present
get the
via
papers
Zoom
in
with
the
the
mail?
respective attorneys, who is Valerie Smolder for Ms. Parmenter and Natalie Montgomery for Mr. Jacobs. This is mother's, the plaintiff's parenting time motion. Looks like child was in a guardianship with the mother's mother, which was terminated for moving to Florida by I think it was Judge Denenfeld. And temporary sole custody was given to Mr. Jacobs. Does that pretty much state what's going on so far?
Yes, yes, ma'am.
Yes, Your Honor.
Child has now been with dad since the termination of it. He finished apparently the child finished school with Mr. Jacobs from last year and is now enrolled in school this year. What are you seeking, Ms. Smulders?
Well, we're seeking the modification of custody and an implementation of parenting time, Your Honor. Essentially, the child had been with grandma nearly his entire life, and dad had been in and out of his life mostly. That being said, my client, because it was her maternal parent, or her parents rather, had a lot of involvement and saw the child daily. Okay,
Yeah,
so
Judge
unfortunately,
Denenfeld basically just gave custody to him for some apparent reason, and Judge Denenfeld did a lot of family law before he went up there. He's not
understood. Yeah. And I'm not disregarding that. I think because I was the attorney for the grandma, for the guardian, I got pulled into that right when the ex parte was issued. I would note that we did an objection to the ex parte. Denenfeld determined we had no standing, meaning grandma had no standing to object to the ex parte that terminated her guardianship. So then moving forward, dad has essentially ceased communication, blocked grandma, which of course isn't really particular to this motion, but also blocked mom from even having communication. So now we have a child that was plucked from everything that he knows. He's with dad, and only when dad decides does mom get communication.
All right, let me interrupt you for a minute. Have you talked to Ms. Montgomery about some parenting time?
No, I have not, Your Honor.
Don't you think you guys should talk about it? Because Ms. Montgomery, it's most likely that I'm going to give some type of parenting time to her. It's not like I'm going to keep her away forever. But at this point, I'm not going to give her primary custody and give him parenting time right now. You should look at parenting time. And don't you think you guys could figure something out?
Well, hopefully the attorneys can figure something out. I'm not sure if our clients are going to be on the same page with that. I was hoping to get out of today, two things. I think if the court wants the attorneys to try to negotiate and try to settle this, that's great. On the back burner, though, I was hoping we could get at least a friend of the court investigation and recommendation, if that's what the court wants to do, or just at least set it for an evidentiary hearing in the interim, just so we have a backup plan, Your Honor.
Evidentiary hearing for what?
For custody and parenting time, because I believe my client has zero custody, meaning legal or physical.
Doesn't appear that she does. And at this point, don't you have to meet some kind of a burden for
yes, Your Honor.
Proper cause or change of circumstance? Because the court ordered him to have sole custody, although I do think it said temporary.
Correct. It's that temporary.
And as a result, you probably don't have to meet proper cause or change of circumstance.
Understood. And in our motion, there are concerns. I mean, the drinking, I guess the child has reported the dad has been passed out in the front lawn. There is only 3-bedroom place, and I believe 11 people live there. It's dirty. We've seen pictures. There's ADHD medicine that the child's taken for 8 years. Now dad's not giving it to him anymore. I mean, so if proper cause or change of circumstances is the threshold that the court is stating, I believe that those things contained in our motion, those concerns.
The threshold, I'm going to tell you right now by looking at the screen that he's going to deny virtually all of them. So I would end up having a threshold hearing, and this is going way beyond what we need to. When did Ms. Montgomery, when did your client obtain the custody?
It was in May, Your Honor.
It's quite a while until she even asked for anything. The child finished school with him and is enrolled in school. What school district is the child?
Oh, I'm sorry, Your Honor. It was March 17th of this year.
All right.
However, we filed an objection when I represented grandma, and I do believe that hearing was in May, if I'm not mistaken.
That was turned down, so he's had the child ever since then. and
Right.
nothing's really been done, and we're in September. We can have, I will, first of all, I'll ask Ms. Montgomery, is there anything you want to say? I'm sure you're going to want to deny half of it and all that.
I do, Your Honor. Also, the client, my client was denied even access to where he was.
I understand that's why he got custody, is because your client, Ms. Smulders, was less than truthful and did not follow court orders.
Not this current one, but yes, grandma, that's what the judge concluded.
Yeah, and if you think I'm going to conclude anything different than Judge Denenfeld, I'm not going to second guess him. There was a clear court order that was denied by the guardian, and your client was there. Okay, you're not gonna walk away from it and say, oh, it was just the guardian. She was there. All right, and it was in Florida also. So I would suggest you don't go down that road very far, because it's not going to be helpful.
Your Honor, we have no problem with parenting time. However, we do have a lack of trust in that. Will she, scoot the child away again without the father having access to him to return? That's his only.
I will tell you that I hear that in every case. And if she scoops up the child and violates the court order, we will find her. We will do it, whether it's prosecuting for child kidnapping. Miss Smulders is going to tell her if she does that. She's already been whacked by the court once for violating a court order. And if we put a court order in as to when she's going to have parenting time and she violates it, she won't end up with anything. At best, she will end up with is supervised. Okay. So I'm just trying to determine, should we provide some type of parenting time? Because I want to provide some parenting time between now and when the friend of the court, I'm going to send it to the friend of the court for custody, parenting time, child support evaluation, see what's going on. Because I don't really think this being a temporary sole custody, I'm not sure that the Varka standards apply, because the judge just said it's no different than a temporary order in a divorce or something like that. It's just to separate them and do that stuff. Now, he's obviously going to have some things on his behalf, like an established custodial environment that's clearly going to be there, and to change something might have to be clear and convincing. We'll see what it comes out with. But I think I would like to send this, and I don't send hardly any to the friend of the court, but I'll send it there for custody, sport, parenting time. And in the meantime, I would like her to have some parenting time. What are you suggesting? Or can the two of you?
Your Honor, she's in the state of Florida.
Oh,
She is currently in Florida. However, her and I have had several discussions where she actually was supposed to come up here for the hearing. However, her family unfortunately got hit by the hurricane pretty harshly. So she plans have changed, but she understands parenting time will be in Michigan. So that is not an issue.
Will be in Michigan. She can have Zoom time with the kids a couple times a week right now. Okay. And any parenting time, I guess now I would like the attorneys to be reasonable and talk, because I'm not going to give her parenting time in Florida.
Of course, I understood that, and she knows that.
It will have to be, I may say that it has to be exercised in Kent County, because Miss Montgomery is going to want to make sure that where she's staying even. And so I'm going to, at least at this point, any order, I would like to see parenting time is as agreed upon between the parties. If they can't agree, you can renotice this motion and come back. But I'm not going to give you, ma'am, I'm not going to give you time in Florida. You're going to have to be here, and you're going to have to work with figuring out if you're going to be living in Florida, then that's going to be whatever we're going to have to deal with. But I'll refer it to the friend of the court for custody, parenting time, and child support. I'm not going to change anything in the current order, which gives him sole custody. Quite frankly, we should start calculating child support from there to him, because he's clearly got all the expenses. Maybe the two of you can work out some kind of an agreement on that, or run some guideline numbers or something. And again, that would be temporary until we figure out what the parenting time and things like that is going to be. So we will make the referral to the Kent County friend of the court. I'm not sure I'll waive the fees, I guess, at this point for both parties. And parenting time will be as agreed between the parties. And that means that the two attorneys will work together to get some agreed parenting time. We'll include at least 2 times a week, some Zoom time, so she can talk to the child and see the child, whether it's Zoom or Facebook, or not. What is it? That's not Facebook.
FaceTime. FaceTime.
Right. I'm old and I don't know.
Yep.
So, just so that she can see the child and talk to the child and do that kind of stuff.
Okay.
Any questions about what an order should include, Ms. Smulders? You can do the part. We will do everything as far as the referral to the friend of the court. To both parties, you need to cooperate with the friend of the court. If you don't, then I only get one side of the story, and I'm going to listen to a lot of the friend of the court. I still make the decision, but friend of the court does this regularly, and that's the only reason I refer it there. All right. And you both have attorneys, listen to them. All right. And to the attorneys, I hope you will negotiate in good faith. I know both of you do. So,
Definitely. All right, thank you.
is it Saturday yet? Is it still light out there? Present via Zoom, and Miss Curry is here representing the defendant, Miss Beelan. This is father's motion for a temporary order. First place, there's no attached AOP to the filing as there was supposed to be, showing that father is even father. Miss Curry, does your client agree that there is an affidavit of parentage out there somewhere or something that makes him legal father? Because otherwise I can't give him anything. Well, you realize you're on mute.
Me?
Thank you.
No, Miss Curry was. All right. She was talking.
My client did confirm, Your Honor, that he appears on the birth certificate, and we both know the only way that can happen is if an AOP was signed at the child's birth. So I have no reason to think
that's not true, and the court does not accept birth certificates as evidence. There is a AOP, and it has to be appropriately filed. But I will deal with this since your client tells me he is the father. But we do not accept those.
Okay, I don't have the AOP, and I saw that it was not attached, but
make sure that one is obtained so that he is the legal father. But since nobody is objecting to it, I'm going to operate as if he is the legal father. Okay.
That's fine.
All right. The other one's joint physical and legal. This is a 5-month-old child.
Yes.
All right. What have you got, sir? What do you want? Joint legal and physical. Is that correct?
Yes. And I'm sorry I wasn't logged on. I do have my affidavit of parentage. I just didn't know I was supposed to attach it. I didn't know where to attach it.
Well, file it with the court with the case number on it, so we got it. And get a copy to Ms. Curry. She'll get a copy to Ms. Curry. She will know what to do with it.
Okay.
Curry, but I know you will know what to do with it. All right. This looks like I was given a document here saying that Mr. Roby, it appears that are you being charged with domestic violence and interference with electronic communications?
I'm going through a court process. The electronic communications has been dropped. As far as the domestic violence go, we're going through the court process to get that dealt with.
So you are currently charged with it? I'm just asking you. That's kind of a yes or no.
Oh, yep. Sorry, I am. Yes.
And is the alleged victim Miss Beelan?
Yes, she is still alleged.
And I have to deal with this case different. So you're still seeking Miss Curry. What are you suggesting? I mean, he is the father. Everybody agrees he's the father. I understand that he probably is not allowed to have contact through his bond with Miss Beelan.
That's correct. There is a bond restriction in place. This was a serious incident. You can see he waived his prelim. It was bound over to circuit court. If there's some resolution in the offing, it doesn't appear on the register of actions I printed off this morning.
He is presumed to be not guilty, and I have to deal with that too. But I don't want him to violate his bond, and I'm sure his bond condition is to not be around Miss Beelan.
It's true. This is a 4-month-old breastfed infant. And I think for now, when you look at the parenting time factors, given these facts, there's no question that this needs to start out with parenting time at Journeys or Safe Connections.
There's nobody else who can supervise this?
There isn't immediately. His mother, with whom he lives, appears in the police report as being involved in the incident that led to the criminal charges.
As far as I was told, they tried to make her out to be a victim, an alleged victim, and she's not my mom is safe.
Well, let me ask you, Ms. Curry, does your client feel that the mother is, I mean, I'm not going to give him any more than a short time, whether it's supervised the Journeys or whatever, but is your client realistically, does she feel that the mother being around there for a couple hours, I'm not going to give a lot of time because the child is breastfed, and this is only a temporary order, and it's going to be there. I'm just asking for an honest assessment from your client. If your client does not feel, then we'll work on how the child is going to get there. I'm not going to make her be around this guy because he's being charged with domestic violence against her. But
And I would just say, obviously, I asked my client that question, Your Honor, and I reviewed the police reports because this arrest occurred at the home where the grandmother was present. And under those circumstances, I think, at least to start with here, until the criminal case perhaps is resolved, it needs to be in a neutral setting.
because your client does not feel safe with it being over there?
She doesn't feel, I mean, I think she feels understandably that the grandma is conflicted and agitated by this arrest of her son and would not be the best person right now to be a supervisor. I would hope that that could change within a relatively short period of time.
Is there anybody that your client thinks could be an appropriate supervisor for a few hours, a couple days a week? Well, sir, I'm kind of in a real difficult situation here, okay? Because there is a criminal charge that keeps you away from her. There's a very young child, and that, I mean, I'm trying to get you some time, but I understand the alleged victim is not going to be too happy about being around you.
Around me. My child is also on formula. She uses formula and breast milk.
Well, but I mean, if you go to Journeys or Safe Connections, you're going to get like 1 or 2 hours a week. I'm trying to see if there's something that can be done to give you a little bit more, but because the charge against you, I got to be careful. I'm not allowed to just put you together and stuff like that.
I understand. I don't want any interaction with Kay. I'd rather it be her mother or somebody within her that can supervise the visits.
Ms. Curry, I'm just asking you that. I'm trying to find something because it costs and you'll only get an hour a week, and there could be a couple hours and a couple of times a week, because establishing some type of contact is really important early on in a child's life, like you know. And I'm
fine, Your Honor, if you want to put me in a breakout room with my client, given what you've said here, I could discuss that with her, and then maybe you could bring us back after you do one other motion.
I'll do another motion, sir. I'm going to put them in a breakout room together. I'm going to put you back in a waiting room and see if we can come back in a few minutes and see if we can work something out, okay?
Yeah, will I get a chance to like speak or anything?
Well, you will, but
okay.
Make sure you're brief, because I'll be going all day on this stuff, okay? I'm doing what I can, and I'll give you some time, but I'm warning you up front that I can't give you a lot right now.
Okay, I'm just trying to get my child. I ain't seen my child.
I understand what you're trying to do, and you found yourself in a mess because of domestic violence, or at least alleged domestic violence. I'm well aware of the burden of proof that she has to go through. I'm well aware of your presumption of innocence, but at the same time, you have a bond that prohibits you from being around her. I assume the bond does not prohibit, Ms. Curry, him being around the child.
I haven't seen the actual order. I need to come over and look at the circuit court file to see if they just took the bond order from the district court, but I just filed my appearance yesterday, and I've not had a chance to physically look at that criminal file.
All right. See if you can talk to your client. If we have to, we'll either adjourn it or we'll do something in the short term.
Okay.
All right. We'll
Thank
put you in breakout room. Mr. Roby will bring you back in a few minutes. Ms. Curry's had a chance to talk to her client. Is there anything at all, or Ms. Curry?
Yes, there is. Obviously, we would be asking for an entry of a temporary order that provided for temporary joint legal, temporary physical custody with my client. We would ask that child support be referred to the FOC, because this is a child who's on Medicaid, and there should be a support order put in place quickly. Regarding parenting time, my client would offer that he could have parenting time every Sunday from 2 to 6 at his home. We would not require it be supervised, and she would have a third-party relative transport the child to and from his home, and we would start on Sunday the 17th, just so we can set up the transportation.
All right, Mr. Roby did want to say something. Mr. Roby, I'm kind of inclined to follow that for right now, because it's only temporary. It is very temporary, but it gets you at least some time with your child. What would you like to say, sir?
I just want to say, I'm just here. I just want to do the right thing for my child and just be in my child's life and raise them.
And you will get your chance to. You're under the gun right now because of the criminal charges and stuff. They're serious charges, and the court, in every best interest factor and stuff, for children and parenting time, and every one of them says domestic violence. And I have to consider domestic violence in it. If in fact you're convicted, and I'm not saying you aren't, but I also can take some amount of notice that you've gone through at least a probable cause hearing, or at least waived it. So there is probable cause to believe that there is domestic violence and or interference with electronic communications, which is a worse form of, not worse, but it is as bad a form of domestic violence. And so I've got to take that into consideration. You're going to be given your opportunity to raise this child or be a part of this child's life. You're just having a difficult time right now. I'm inclined to offer a temporary order, just like Ms. Curry said. Joint legal will allow physical to mother right now. This isn't anything permanent. This isn't anything you're going to look at when your child is 12 years old. Okay, this is going to be probably until you get through your criminal trial. Or something like that. And also because the child is nursing, and if she needs to provide some formula or something, Miss Curry, or pumped milk or something like that, she can provide it to him through the third party. We'll have the third party drop the child off with you at 2:00 and pick up at 6 starting next Sunday. I'm going to refer the matter to the friend of the court for child support because there is state funds and we do need to get that started. And you need to start to accept what's going on. We will work with you on increasing your ability to have time with your child. But I mean, you're behind the 8 ball right now with those charges. And I'm just,
okay.
Anything else you want to say?
No, Your Honor.
All right.
Just thank you for at least considering and giving me the.
And what I want you to always remember from here on out, I'm not saying whether you did or didn't do domestic violence, but you have to always act like you want to be treated, okay? You want to treat others like you want to be treated. You have to understand that you have a child now, and if you want to be a real part of his life, you need to start always doing the right thing, right? And you will succeed in this case, maybe not as much as you want, but you will succeed if you do the right thing. So I'm just saying this right now. If Miss Beelan, who has given you more than I might have given, okay, if she has somebody drop the child off and you give them any grief for doing that, because I'm sure they'll have a cell phone and they'll be able to record you. If you aren't anything other than polite, and if you aren't anything, it will not go good for you. You need to change, and you need to do the right thing every time. That person who's going to drop off and not, if they say they don't want to do it anymore because you're a pain in the neck, you're going to go have visits at Journeys and you're going to pay for them.
Okay, so is there any way on my end that I can prove that, like, say if they try and make something up and say, well, he said this and that, is there any way?
You can get a cell phone if you want to record things, but there's no reason that they would. She's offering you this. Why would she send somebody over there to cause problems? She's giving you this time. It doesn't make any sense to me. So I'm just trying to make sure, just so I'm protected also. Right. So nobody. Yep. It's time that you always do the right thing. Ms. Curry, you can draft the order. Ma'am, you have to pull over. I'm not allowed to have a hearing with you driving.
All right.
I mean, this is Dad's custody motion. Basically, there was a judgment of support back in 2019 that gave initial custody to mother without prejudice to either party, determined by a court. Dad says mom's not letting him see the child. Mom says the child's nonverbal, autistic, and has concerns. First off, because he has asked for a custody hearing, and the court specifically says in its order that initial custody is given to mom, but without prejudice to anybody requesting a court determination, I have to have a hearing for that. But I plan on referring it to the friend of the court first for a custody, parenting time, child support evaluation. But I do have to have a hearing on it unless the parties agree on something after the friend of the court. Sir, what else is it you want to say?
I just want joint custody. Like, she's not letting me see her at all unless I come over her house, and I don't feel comfortable being over there. And I just don't understand why I'm not allowed to see my daughter. Like, she don't even have full custody of her.
But she has
you do
custody
understand.
right now.
You know reason why you can't see her, or why you haven't been seeing her. So I would like if you would tell him the reason.
That don't have nothing to do with me.
Okay.
At this point, she has initial custody. I have to have a hearing to determine what final custody would be. But she has custody right now. You are probably entitled to some parenting time. And what I'm gonna do is I'm gonna send it to the friend of the court to make a determination of what is appropriate for custody, parenting time, and child support. When you say you want joint custody, I don't know what you mean by that. You want 50% of the time?
Yes.
You're gonna have a tough time with that because she's got an established custodial environment.
And he doesn't even have his own residence or live with himself. The person he lives with has an active PPO order on me.
That will be something that the friend of the court is gonna look at: custody, parenting time, and child support. They will be in touch with both of you, and they will expect you to participate as they require. They're gonna ask to interview you, things like that. They're gonna get your documentation. They're gonna go through that. They're gonna make a recommendation. If you don't like the recommendation, you can object to it. If you do, it'll be entered as an order, but they're gonna do that. And do both of you work? I mean, it's costing
Yes.
$150.
I have 2 jobs.
Yes, I have a full-time job. I work with autistic kids.
Can both of you pay the $150 to go to the friend of the court?
Yes.
Yep.
All right, we will refer it to the friend of the court and defer any kind of further hearings until we get something from the friend of the court. There will be a order that will come through to both of you, and it will require you to pay the friend of the court within like 14 days. Please do that, because otherwise the friend of the court will say, no, I don't want to do it. And we'll be back to square one, and I will be angry at whoever didn't pay it because you both said you could. All right?
All right.
All right. Cooperate with the friend of the court, and I'll see you back probably in whatever time it takes them to get present by
right.
Zoom. This is a
Thank you.
request from father for an order to show cause, because the mother didn't bring the daughter to appropriate soccer tryouts or whatever it was. Ms. Pintarelli, is there any reason why you didn't have her there on time? Ma'am?
Oh, which one?
Well,
The first one we weren't there.
The motion,
Huh?
mother refused to bring the child to the soccer practice on time. She came extremely late. Result in daughter missing practice. You know,
So I didn't receive any paperwork for this. I have nothing. The only reason I am here is because I received a text message stating that I had a court date. So I have no idea what.
When did you serve her with this?
The day that weeks ago. So, I mailed it off weeks ago. Then I also sent her, a copy via text too. So she received that.
Let me ask the first question. Is Miss Van Dyken, involved in this case yet?
No, not yet. I'm still scraping up the money, sir. So I'm working on it.
All right. Tell Miss Pintarelli when it was that she missed the soccer practice.
It was her first game, which was the 2 Sundays ago. So, and she was well aware of it. I've copied emails and text messages.
Is there any reason why you didn't get her there, ma'am?
I did get her there.
On time?
Not on time. We were at, I thought it started later than what it did. It started at 4 and I thought it was 4:30. We were at a family reunion. Isabel was playing in the water. I kept trying to get her out, and then we finally made it up there. So I did end up talking to the coach.
All right.
And I believe I do have pictures of that day too. So.
Yeah. Oh, Your Honor, I sent all the text messages to me contacting her throughout the whole day.
I understand.
Yeah, and then it happened again this past Sunday when she had her, and she showed up extremely late. This is when it.
Did you show up late this last Sunday?
We were there.
On time?
I don't know what time we got there. It wasn't too much after the game though.
Well, why can't you get her there by the game time?
Well, because we usually are doing.
I understand, and I don't know what am I gonna do? You're supposed to get her to her games and practices and stuff, and I know it's difficult because you're in Kalamazoo, but this is your child, and she deserves to get there. She deserves to get the games and stuff like that. That's why she's on the team, and she's not gonna be on the team very long or do very good if you don't get her there. I mean, you're gonna force me to make you return her home Sunday mornings at this rate. And I don't want to do that. What can I do to make sure you're going to show up on time?
Well, because we're busy doing other things and it's hard for me to get her to stop doing those things so that we can get there
How
on
old
time.
is she?
I know.
How old is she?
9.
You're the mother.
I can answer for myself.
What?
And yes, I know that I'm the mother.
Okay, but you gotta, if the game is at 2 and it takes you an hour to get up there at 1, maybe you need to start saying at noon, okay, we gotta start getting ready to go and go. I mean, I have
It's at
those
4
picked
now
up.
that I know.
What?
It's at 4 now that I know.
Are all of them?
I don't contact Mr. May because he's told me several times not to text him.
Ma'am, Mr. May, does she know when the time, are they all at Sunday at 4?
She's very well aware of it. Yeah, they're all Sunday at 4. I've emailed her, I've texted her,
All right,
give her
all right.
copies of it.
Miss
but-
Pintarelli, I'm not gonna put up with the kid being late anymore. All right? I don't know why this is, if you know you gotta be there at 4, get there at 3:45 so she can get ready to play the game. Is that a school event, Mr. May?
Yes, it is. All events. Yes, it is. It's part of school, East Kentwood. And so it's their soccer program. And to add to the record, this is the same one of the reasons that Isabel doesn't like going over there. Same reason Darian doesn't like going over there.
I understand. I'm trying to, ma'am, you just gotta get her there.
You don't put sports over their well-being. That should be their first priority right there, is you don't put sports over their well-being.
What's their well-being?
She's already been hit by a car and molested. Are you kidding me?
So you're saying she shouldn't be in sports then from then on?
I didn't say that she shouldn't be in sports, but I'm saying that we have limited time together. I'm not the one that's raising them right now. So if she comes down here acting up or too independent, telling me what to do, then that's something that I need to work on.
I'm telling you to get her to those events at 4:00. You get your time with her. The only other way I can deal with this is take the time away from you.
You've already taken a lot of my time away, and look what's happened to these children.
Then appeal my rulings.
What if people just don't have time or the means to do that?
What do you
Then
mean?
the children suffer.
What do you mean that? What makes you think that a kid shouldn't play in their school soccer program and you just
I didn't
decide no?
say
I'm telling
that
you right now that the child will be at those events on time, or I'm going to take some type of action. I'm trying to.
You're always taking away my time and never giving me any time.
I'm not gonna argue with it. I'm telling you to be there on time, or Mr. May, you can file a motion and I'm gonna have to have her, something's gonna have to happen.
Yeah,
I'm
you're right.
trying not to take any time away from you. It's as simple as that. I'm trying not to. Just get her to
No,
her
just
soccer
do
games
everything
like
that
she's
Mr. May
supposed to.
says.
What?
Just do everything that Mr. May says.
No, do what I'm telling you. She's in her school soccer game program, so
I don't
she should
believe
be
it's for
allowed
school.
to. What?
I don't believe it's for school. I'll look up the.
You look it up and
Believe
tell me
it.
different. But she's still enrolled in it, and there is no reason she should not attend her soccer games. You can stay there with her. You can watch her.
I do stay there with her.
Have fun with her. Doesn't mean, I mean, this is part of kids. That's the order of the court, that you will be there for all on time, or you can file another motion. Thank you.
Thank you, Your Honor.